compelling circumstances, I'm beseeching your lordship to take the matter urgently, my lord. What has happened in 2007? My father died, and till date, I am praying before the authority for giving the compassionate appointment, but they are not taking any single steps, my lord.
What is the urgency all on a sudden?
My lord.
What is the urgency all on a sudden?
The ST category candidate, my lord.
Yes.
Lady, more or less, she will attain the age of 40.
2007 and 2027 will
My
be
lord, kindly,
just a few months. No, yes.
let it be included, my lord, in the list, because
Today is not the day of mentioning. I will not allow any mentioning either for inclusion or upgradation. Anybody over here, please listen to this.
Well, second,
Nothing. Nothing.
My lord, under compelling circumstances, my lord, I have challenged the interview rounds. The interview have commenced today.
What do you want?
My lord, the cancellation of the recommended list, because the list has been wrongly prepared. My lord, kindly takes up the matter. The interview round has already begun today. It will be continued till 12th. My lord, kindly takes this matter up. It's running in
the mentioning. No.
My lord, the interview has already commenced today.
Restoration application.
No.
When I find restoration,
May I be permitted to mention the matter for one contempt application?
For what?
Contempt application.
Contempt is the matter. Why are you mentioning? For what reason?
My ladyship, for the non-compliance of the order that has...
That is why contempts are filed. Why are you mentioning today?
My ladyship...
Come prepared.
My lord, আমার certified copy.
Matter.
My lord, I just mentioned this matter.
Where is your matter?
My lord, my matter is running in the item number 263 of the
It will
monthly
be
list.
done immediately. Just wait. Yes, call the list,
Lord,
please.
my lord, may please, my lord. My lord, I seek leave for filing a review petition without any certified copy, my lord.
When was the order passed?
My lord, the order was passed on 27th March 2025.
25.
Yes, ma'am.
We are in May 2026 and you want to file a review application without a certified copy. And you have the guts and the courage to mention this before the court. Just go and make an application for the certified copy. Yes.
My lord, I am for the petitioner, my lord.
Yes.
And for Coal India Limited.
My lord, I have, by filing this writ petition, has challenged a selection process on, my lord, on principally one ground, that is, my lord, they have adopted the selection procedure or marking system after the selection is over. After, my lord, publishing
when did the selection commence?
My lord, 25th of February 2025. My lord, kindly consider page 26.
Yes, 25th notification 2.
Yes.
This is the, what is the stage now? Final
Stage,
result
my lord, no.
Yes.
My lord, they have, my lord, when I filed this writ petition, they have, my lord, uploaded a list of a provisional list of candidates. Then 4th, my lord, the matter was taken up for consideration by your lordship. My learned friend chose not to appear. Then matter has been fixed today.
I don't
now
see why
on
he
5th
has to make such submission that I
yes,
chose
yes,
not
he did
to
not appear.
I did
Then
not
on
appear.
5th,
Say that.
when your lordship is in session of the issues, my lord, they issued this final list. Although no one has been appointed, therefore no right has been accrued today. Your lordship can
Yes.
certainly decide and pass order, my lord. Now, my lord, may I just indicate, my lord, the brief facts of the case? Your lordship, kindly consider page 26. This is the notification dated 25th February 2025. My lord, kindly consider the first paragraph. For promotion or selection of departmental employees from non-executive cadre to executive cadre in the 16 discipline in E2 grade as mentioned below. Then, my lord, your lordship will find that kindly consider page 27. Serial number 2. This personnel, my lord, kindly see minimum qualification graduate with postgraduate diploma or postgraduate degree in social science or labor welfare as recognized by Labor Ministry for the post of welfare office in mines. Then minimum experience, kindly see nil. For other discipline, my lord, there is some experience which has been recorded, but so far personal discipline is concerned, they said minimum experience is nil. Then, my lord, your lordship, kindly consider the next page, page 28. Serial number 10. My lord, for personal discipline, there were 142 posts, my lord. Serial number 10. Then, my lord, kindly consider page 30.
Yes.
My lord, serial number 6, it deals with methodology and other norms. Kindly consider Roman 6. The last 3 lines, the final promotion or selection merit list will be based on total marks secured by candidate out of 100 marks on the weightage comprising of written test 65%, qualification 10%, experience 10%, and ACR 15%. Performance rating should be at least good for the last 3 years under review, that is 21-22, 22-23, and 23-24. Average, adequate, barely adequate will not be considered fit for selection. Thus, applicants who are not having desired performance rating for the last 3 years as on the cut-off date will not be considered. Total written marks secured by the candidate out of 200 marks will be proportionately scaled down to 65 marks, and rest 35 marks is earmarked to qualification, that is 10, experience 10, and ACR 15, making a total of 100. Minimum overall marks for the empanelment of unreserved candidates out of 100 is of 60, whereas, my lord, this is not required. Then, my lord, kindly consider page 35. My lord, this is, kindly consider page 33. 33, my lord, is a frequently asked question. Relevant is page 35. My lord, question number 9. What will be the total marks or questions, medium and scheme of the examination? The written test will be conducted through computer-based test. Total 200 marks. Each paper, paper 1 and paper 2 shall have 100. Now, rest are not relevant, my lord. Then, my lord, the petitioners, my lord, sent a legal notice at page, which is at page 48. Kindly consider page 48 once. My lord, page 48 in the middle, my lord, in bold, my lord, kindly consider this. Concerns were noted regarding deficiencies in the process, such as the lack of clarity about the marks assigned for experience, qualifications, and annual confidential reports. So, my lord, candidate said that there is a lack of transparency. So far, these 35 marks are concerned, 65 for CBT, and then the 35, my lord, they said that there is no breakup. Now, my lord, your lordship, kindly consider they appeared in the selection process. Kindly consider page, my lord, 128. My lord, the CBT was held on 29th November 2025. Kindly, my lord, mark this. 29th November 2025, CBT was held. Then 2nd of December 2025, my lord, kindly consider page 128. That is after the CBT, my lord, they issued this page 128 notice. This is dated 2nd December 2025. The response query management inviting query or objection regarding questions or answer, if any, from the departmental candidates who appeared in the computer-based online test held on 29th November 2025 for promotion or selection from non-executive to executive cadre will be made live in the CIL website since 2nd December 2025 to 6th December 2025. Therefore, my lord, CIL, my lord, asked the candidate, my lord, to raise objections or queries. Now, my lord, they, without, my lord, publishing the model answer key, they, my lord, publish the provisional list, which is at page 130, 129. The next page, my lord.
No, page 128, the response query management inviting query objection regarding question answer.
Correct.
And this was done without the model answer key being published.
Yes. My lord, initially what they have done, they've uploaded or sent, my lord, their answer scripts to all the respective candidates. Thereafter, this was done, my lord, this answer script was sent, my lord, on 15th March 2026, subsequently, my lord, on 15th March.
2nd December, this notice, what type of query or objection could have been
We
raised?
do not know. We do not know. After the CBT was done, written
Yes.
examination was done, the CIL, my lord, directed the candidates, my lord, to raise objections. This is, my lord, absolutely, my lord, unheard of, my lord. Then, my lord, without publishing, they received some objections or queries. We do not know, but ultimately, my lord, upon receiving those, they did not, my lord, upload anything that these are the final keys. Without uploading anything, they receive what they have done, what decision they have taken, we do not know. We were kept in dark. Then, my lord, they all on a sudden, the next page, published this note list of provisional list of candidates. Kindly see 15th March 2026. List of candidates recommended provisionally for promotion or selection to the post of senior officer in E2 grade based on DPC held on 14th March 2026. Now, my lord, after filing this, my lord, I found, my lord, this in the this one. My lord, this was done by an agency. Now, it is the duty of the agency, my lord, to publish the model answer key upon receiving those queries, my lord, within 10 days. Kindly consider this, my lord, page, this one.
What is this?
My lord, this is a Coal India's document, my lord. This was, my lord, an agency was appointed. And kindly consider, my lord, this first page, hiring of recruitment, draft NIT for hiring of recruitment agency through open tender in GEM such and such for conducting various recruitment processes. Now, kindly consider, my lord, the second last page, my lord. Second last page. I do not know, my lord, whether exactly, my lord, these terms and conditions were incorporated in the final agreement or not. Kindly consider the second last page, clause 37. Objection management link shall be hosted on CIL website by selected agency after the conduct of CBT, inviting concerns of the candidates related to questions and answer keys of the examination, if any. Selected agency will keep the portal open for 7 days after the examination to receive the representation of the candidates in respect of the answer keys. After receipt of the representation of the candidate, the bidder will, that is the agency, will upload final answer key within 10 days of closure of the representation window. Therefore, my lord, the agency is under an obligation, my lord, to upload this final answer key upon receiving those objections. Here, my lord, they received this notice was issued on 2nd December 2025. And my lord, your lordship will find the last date to raise objection was at page 128, 6 December 2025. Kindly consider 2nd December 2025 to 6 December 2025. Therefore, they were under an obligation, my lord, to upload the final answer key within 10 days therefrom. Therefore, by 16th of December 2025, my lord, they were under an obligation, my lord, to upload the final answer keys in terms of this, in terms of clause 37. Kindly see the last line, my lord. This has not been done. What they have done, my lord, they maintained a stoic silence. Then, on 15th of March 2026, my lord, at page 129, they uploaded this provisional list of selected candidates. Now, my lord, the most interesting thing is, my lord, kindly consider page 136. The selection list was published, merit list was published on 15th March 2026. Now, my lord, what they have done at page 136, kindly consider, my lord, the date 27th March 2026. Reference is invited to the clause number 66. Clause 66, my lord, I have just now placed page 30 and page 31. Methodology and other norms of the notification. Then 02/2025, the marking pattern in respect of experience 10 marks, qualification 10 marks, and ACR 15 marks, as per the circular dated 16th November 1984. Therefore, my lord, by this time, my lord, the selection processes were over. They prepared a list, uploaded it. Then on a subsequent date, 27th March 2026, my lord, they decided that under which manner the marking will be given. Kindly consider, my lord, page 140. They, my lord, referred to a circular. There are several circulars, my lord, of CIL. They, my lord, they have adopted a pick and choose theory. They, my lord, said that they will adopt the circular dated 16 November 1984. Then kindly consider page 140, my lord. After the selection process was over, my lord, the CIL decided how the marks will be given. The first paragraph, my lord. Marks awarding criteria, HR, personal discipline. Candidates having minimum qualification, that is graduate with postgraduate diploma or postgraduate degree in social science or labor welfare as recognized by Labor Ministry for the post of welfare officer in mines, 6 marks. Then candidates having undergraduate degree in law, 1 mark. Candidates having postgraduate degree in law, 2 marks. Candidates having degree, diploma in computer application, minimum 6 months, 1 mark. Therefore, my lord, these marks were not there in the notification dated 25th February 2025. If, my lord, the CIL, my lord, can show that they have decided this on the date when the notification was issued on 25th February, that this way the marking will be distributed, any decision on 25th February or prior to that, then there is no procedural impropriety. But if it is taken after the selection process is over, my lord, this is absolutely illegal. Now, my lord, kindly consider page 155. My lord, the notification was issued on 25th February 2025, and page 155 is the 156. I'm sorry, my lord. Yes, 155 is the HR manual, the first page. Then 156, your lordship will find updated as on 1st October 2024. Therefore, prior to the notification dated 25th February 2025. Then kindly consider page 156. I'm sorry, 158. Clause 1.5, departmental candidates, my lord. Well, this entire selection process is a departmental promotion. Kindly consider, my lord, clause 4. For the purpose of selection of departmental candidates against the press advertisement, the criteria laid down in the cadre rules will not apply. Instead, only the criteria stipulated in the press advertisement will be guiding factor. Therefore, my lord, whatever they will publish in the advertisement, that should be followed. Now, my lord, there are 3 illegalities, my lord. If my lord, your lordship, allow me to sum up. The first illegality is, my lord, that the agency, my lord, received, my lord, objections or queries from the candidates after the CBT was over. Now, my lord, once they receive these objections, my lord, it is their duty in terms of that agreement, my lord, executed between the CIL and the agency, that they should upload it within 10 days, my lord, from the last date of that receiving queries. This has not been done. My lord, the second illegality is, my lord, that they have not published the final merit list, my lord, including the names of the unsuccessful candidates. It is their duty, my lord. It is not that the final merit list should not be, my lord. This is a select list. The merit list includes the names of the final merit list. I have a right to know that where I stand. Therefore, my lord, that has not been done. My lord, the third illegality is, my lord, when the CIL, my lord, or the agency, my lord, I will say CIL, my lord, decided that they will, in a particular manner, distribute marks. This has been done, as it appears from their records, that this has been done after the selection process was over. Now, my lord, in either midway or, my lord, once the selection process is over, this is absolutely illegal, my lord. This cannot be done. Therefore, CIL is under an obligation, my lord, to show that this decision was taken either on 25th February 2025 when the notification was issued, or any date prior to that date. And lastly, my lord, it appears from the HR manual, my lord, that they should follow the advertisement. They should follow the press documents. The press document is absolutely silent so far experience and other things are concerned. They said experience, it should be nil for personnel department. Therefore, everyone is, my lord, entitled to receive full mark since the advertisement says that there is no requirement of experience, my lord. Therefore, these are the illegalities they have trying to accommodate their favored candidates. Your lordship, kindly, my lord, consider these issues. And, my lord, in the meantime, my lord, I shall request your lordship to, my lord, pass an order of status quo till, my lord, the Coal India comes with instruction or report, my lord. My lord, these are my submissions.
Yes, please.
Your lordship, you'll see all these candidates are from personnel department. They mostly work for HR and all. They are aware of the circulars and how the process works. They handle many of the parts of it. My learned friend has talked about a few things which I'll show. First, about the first notification of 2025, which is at page 26. At page 30, it provides the methodology.
No, page 26 is the notification, and page 27, the experience in respect of the personal discipline is nil.
Nil.
Right? Thereafter, it has been shown that you all have taken a decision to award marks on account of the undergraduate degree in law, postgraduate degree in law, in diploma,
No, your lordship,
in other things.
it's with
Where
respect to additional degrees. Your lordship, my learned friend has said
Yes.
that 1984 circular is referred there. He says they have chosen one of the many circulars. That is the
Right.
only circular. They are in personal department. They know very well. But
How
they say
could you
it's one of the.
Assuming you choose 84, where is this mentioned? And then the other note.
It is mentioned in the 27th of March. Your lordship, the rules had never changed. The further circular which came, it only reiterated what was there in the earlier one. It doesn't change. Everyone is supposed to be aware of what the marking system is. Here, it's given that 10 will be for ACR, 10 will be for the experience. They're aware how it is done. It's there from 1984. It's an established.
They're being aware of it.
It's
They being aware.
Your lordship, it's an
Thing is,
established
your
part.
notification should disclose that these are the parameters relying on which the promotional examination is being conducted. How could you deviate from
No,
here?
because your lordship, after that, they have to submit documents.
Which document?
Documents, like when they have filled up the forms, there is a field provided for everything. That for the main qualification, for the additional qualifications, for everything they have to upload document. If they don't upload documents, then they cannot come back and say that, see, I was not aware that I have to give something.
Sir, your minimum qualification for promotion requires a graduate with postgraduate diploma or postgraduate degree in social science or labor welfare.
Correct.
Nothing else is required.
That is the minimum qualification.
Yes.
Then there is a mark which is given. Your lordship may kindly see this 1984 circular. Your lordship,
Why
because it is nothing new.
To it. Why will the 1984 circular be looked into?
Because, your lordship, that is the established principle on which Coal India recruitment has been happening for so many years. 40 years.
Where is the reflection in the recruitment notification? There is no notification. There is no reflection. On the contrary, this has been shown. Your
lordship, that's a tender notice. What my learned
not
friend.
the tender notice. The last one. The very last one where it has been shown that only the press notification will be
The HR manual.
HR manual
The HR
of
manual.
2026 as updated on 1st October 24. Page
But, your lordship, that
156.
provides that what is the division of marks between the written, the interview, and the ACR. And that is an established part of the Coal India practice. that what is
Your-
awarded for what.
HR manual as regards departmental candidates mentions
Correct.
that for purpose of selection, only the press advertisement criteria will be followed.
Lordship, we have not deviated from that. We later on, just because there were certain queries raised, we have given the bifurcation of that. There is no change in the marking system. And your Lordship, my learned friend had also
The
mentioned.
moment you say that queries raised, that means there was scope for raising a query.
No, your Lordship,
People
because the
had
1984
query
circular
in
was
the
always
mind.
there. Your Lordship, persons raise query because they have not been successful. And then we gave the clarification. Your Lordship, it's only in the interest of transparency that we reiterated that it is already mentioned in the 1984 circular and we are following the same thing.
And you say you do not have any other circulars.
No, let my learned friend show.
Because submission is that you've picked up only the
No, no, Your
1984
Lordship, my learned
circular.
friend has not showed any other circular. Because Your Lordship, there is none.
There
Because
is
Your
none.
Lordship, this circular is only with respect to selection of promotion from non-executive to executive cadre. That is the whole encompassing issue of this matter. This is only the promotion, and this is the circular, how the bifurcation of marks are there. We have not done anything
Why
new.
is not one line mentioned in your notification for promotion that this 84 circular is to be followed? So there is no question of any query being raised by any of the candidates.
Your Lordship, the query
Isn't
also,
anything mentioned?
my learned friend, what my learned friend has showed that legal notices, Your Lordship will see, one of them is not even signed by any advocate.
No. Legal notices the court is not looked into, and he has not placed also. Legal notice I am not considering.
Yes.
Right. Thing is, whatever is there in your recruitment notice and the steps taken consequent thereto, that will be considered. Legal notices the court is not considering at all. Right. So
But Your Lordship may see if we have actually deviated from any of
this
those.
is the only thing.
We have
Whether
not
the
deviated, Your Lordship may kindly see, no deviation from the notice of recruitment has been shown.
all right, you filed
Only
your
one clarification has been given.
response. You file your response by way of an affidavit, and
And Your Lordship, one more issue, which Your Lordship cannot really be shared. My learned friend had also made a submission that whether any decision was taken by Coal India Limited before the recruitment. Your Lordship,
decision
regarding the bifurcation and this 1984 circular before publication of this recruitment notice.
all right.
Lordship may see the office.
No, you can
It
annex
was
this.
approved. It was approved.
If you feel that this is necessary, you can annex this with your opposition. The court will look into it. And what about this promotion order, the select list that you have published on 5th of May 2026?
Your Lordship, till 4th, the model code of conduct was there. These things were ready. There were thousands of recruitment notices which have been published, the
Yes.
transfer notices, and they have been allotted the joining places.
All right. Please come.
But Your Lordship may kindly consider that each person's case, my learned friend has not made out any case that they are even within any zone of consideration. Only a hypothetical case after they have participated in the
How
process.
know that they are within the zone, outside the zone? How far they are from the
Because-
zone of consideration?
Because Your Lordship,
You
they
didn't
have,
publish the final list showing
yes,
the-
Your Lordship, the final key, the answer key which my learned friend is saying, I'll show Your Lordship.
not the
Your Lordship,
final answer key.
Because
the
Your Lordship, it can be easily calculated from there how much they
the list of the candidates,
Yes.
selected candidates for promotion, right?
Yes.
Where is their position?
Because Your Lordship, the provisional list from top has been published only with respect to, Your Lordship, there are thousands of candidates. We don't publish all list of unsuccessful candidates. Whoever is, there is a provisional list that is only published. Your Lordship, that's
And
a
the
very,
gradation list is there. You have a gradation list.
it's there.
What is there?
Your Lordship, the gradation as regards the marks obtained, it's there. The marks
No,
can be-
marks obtained in the promotional departmental examination, that is different.
Mhm.
Do you have a gradation list,
Mhm.
a merit list, a seniority list that is being followed?
Yes. Your Lordship, because Your Lordship will see the recruitment criteria also. This is one of the tiebreakers. Like if two persons secure the same mark, then the senior one gets the position. So
So
the
the
gradation is always there.
Seniority list is
Yes,
maintained.
Yes.
Well,
They are nowhere there.
My lord, in reply, my lord, may I just make one submission, my lord? My lord, this is the 16th November 1984 circular.
Hmm.
My lord,
Yes.
it cannot be, my lord, the CIL cannot adopt this because it says about interview also. Here there is no interview. Therefore, this will be a defective.
All
because-
right.
No, your lordship may see the circular says
All right.
specifically only with
And
respect
there
to ACR and experience and qualification, this circular is applicable. Your lordship is hearing the other matter where the interview was there and the exam was there. After that notifications, the process has been changed. Everyone is aware. Now, while
No,
understand
it is
raising
not a
this
matter
issue.
of everyone being aware.
Your lordship, it's
Things have
contained.
to be
It's
very,
contained in this.
very transparent
It's
so that
contained in the
nobody
circular,
can
your
point
lordship.
fingers at the employer.
Certainly, your lordship, it's contained in the circular that 65 marks is the exam and then 10 marks is for experience, 10 for qualification.
If you
15 for
choose to incorporate details of only 65 marks and then you remain silent about 40 and it is you think it that I'll apply the 84 circular, by that way it
your
becomes
lordship may
difficult.
kindly consider no
Acha,
the
likhun to
bifurcation of
Well,
65 is
only-
given, but for the bifurcation of 35
the
it's given. here.
promotion/selection of departmental employees from the non-executive to the executive cadre. Initiated by Coal India Limited, Vire notification number 02/2025 dated 25th February 2026 is the subject matter of the instant writ petition. Stop. The petitioners participated in the promotional process. Stop. They allege that the manner in which the promotional process has been conducted is contrary to the notification dated 25th November 2025. Stop. The employer has sought to change the rules of the game after the game had begun. Stop. The authority took a decision to disclose about the distribution of marks after the entire selection process was over. Stop. Despite the despite the provision for following the HR manual as updated on 1st October 2024, clearly mentioning that for the purpose of selection of departmental candidates against the press advertisement, comma, press, PRESS, comma, the criteria laid down. Now, the criteria stipulated in the press advertisement will be the guiding factor. Stop. Whenever relaxation is required, comma, it shall be with specific approval of the chairman or any authority delegated with such powers. Stop. Paragraph. It has been contended that in the press advertisement, there was no mention as regards the manner in which 10 marks are to be bifurcated. The same has been incorporated vide the notice number 18/26 published by the Recruitment Division of Coal India Limited on 27th March 2026. Stop. New methodology for awarding the marks have been adopted, which is contrary to the press advertisement.
Your
Stop.
Lordship, that is not the case. They have not argued also this thing.
Just
That is
now it
exactly
is
my
No, no, there
question.
is no contrary provision.
very well. You take
Just a
your
bifurcation.
On the next
Just
day, my lord,
bifurcation.
I shall produce
in your
2002 circular.
Your Lordship, you kindly, just a bifurcation we have. There
At
is no-
least there are
whatever.
two circulars, my lord.
paragraph. It has been submitted that the final answer key has not been uploaded within the time limit stipulated for the same. Stop. The list of candidates granted promotion does not contain the list of all the participants who participated in the promotional examination.
I tender my apology, my lord. Kindly consider page 41 once, my lord. I'm extremely sorry, my lord. Kindly consider page 41. Kindly see the last box, my lord, serial 10. The DPC to be constituted as per, this is in connection with this selection process. The DPC to be constituted as per the presidential directive, who will consider and prepare the final merit list and make two lists, eligible and non-eligible, with reasons of non-eligibility. Then kindly see the time limit within 10 working days after the scrutiny by scrutiny committee. This has also not been done.
Your Lordship, they are eligible. Admit card has been issued. Exam is after eligibility.
It has been contended that the SOP regarding preparation of final merit list and the requirement of making two lists containing eligible within single quote and non-eligible within single quote with reasons of non-eligibility to be published within 10 working days after scrutiny by the scrutiny committee. Within 10 working days after the scrutiny by the scrutiny committee has also not been followed. Stop. Paragraph. It has been submitted that during pendency of the writ petition, the authority published a list of candidates for promotion/selection on 5th May 2026. Stop. Prayer has been made to direct the respondents to maintain status quo as regards the promotional process. Stop. Learned advocate representing Coal India Limited opposes the submission and prayer of the petitioners. Stop. It has been submitted that the promotional process was conducted by maintaining absolute transparency and fairness. Stop. All the notifications and the rules relied upon by the authority are well within the knowledge of the candidates who participated in the promotional examination, as they all are departmental candidates. Stop. Paragraph. It has been denied that the rules of the game have been changed as alleged or at all. Stop. It has been submitted that the that in view of the model code of conduct which was prevailing in the state due to the West Bengal legislative election, the list of selected candidates for promotion could not be published. Stop. Immediately on the 5th May 2026, after the model code of conduct was lifted, the list has been published. Stop. Paragraph. Upon hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, the court is of the opinion that the matter is required to be adjudicated upon granting the parties, respondents, an opportunity to file its opposition. Stop. Next. The respondents are accordingly directed to file the affidavit in opposition within a period of 6 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Stop. After completion of the aforesaid time period. Paragraph. It is ordered that any steps taken in respect of the, not in respect, in connection with notification number 02/2025 dated 25th February 2025 shall abide by the result of the writ petition.
Grateful. Great.
Don't call.
From the daily list.
Item number 2, and for the petitioner. Lord, this is an analogous matter, my lord. Lord, the another matter is running in the monthly list as item number 342, my lord. Lord, there is an order for tagging these two matters, my lord. And also, my lord, in respect of this matter, my lord, the service is incomplete, my lord. So, my lord, I'll serve the other parties and, my lord, I'll come back. My lord, to the Union of India.
Union of India is represented.
Yes, my lord,
lord.
Mr. Shukant.
You are there?
Yes.
Union of India?
My lord,
The another matter.
I am also my lord for Union of India, Senior Council Group 2 and Learned Advocate, Senior Council Group 1 is standing before your lordships, my lord, over there, I think. Mr. Ronald Chatterjee.
Lord, kindly peruse this order, my lord. This is the last order.
দেখি একটু
In respect of 17505, my lord, that was tagged with this present matter, my lord.
same, the petitioner is the same.
Yes,
Ratan
ma'am.
Singh
Yes,
Roy.
ma'am. Same. Lord, first one is for the departmental proceeding and second one is for termination. Petitioner is same.
And which matter you did not serve?
Lord, in the second one, which is not appearing, item number 2, Lord, this one.
18614 has not been served. How are councils appearing?
Lord, I have
Shall get a
informed them.
copy.
I have informed them, Lord.
Appearing on behalf of 7505.
Lord, the service is yes, Lord. Lord, I'll serve whoever, my lord, was not served.
All right,
No, I am appearing for the company, my lord, respondent number
company.
two. It's a PSC. Engineering Projects Limited, my lord, that's a central government PSC.
Acha, item 2. Learned advocate for the
Private
petitioner
respondent received the
submits
copy.
that copy of the writ petition is yet to be served upon the Union of India. Stop. Let service be effected. Stop. List this matter along with WPA 17505 of 2025. Within bracket, Ratan Singh Roy versus Union of India and others. Item number?
My lord, item number 342, my lord.
Item number 342. Please check.
The list.
Animesh Babu. 342 of
342.
the monthly list. This month. May. Let both the writ petitions appear on 8th June 2026. A respondent shall come ready with all necessary instruction on the adjourned date.
Grateful, my lord.
Private respondent, did you enter your appearance by way of Wakalatnama? Wakalatnama filed?
My lord, can the date be on 10th, my lord?
Why?
Lord, I will not be available, my lord. Lord, 10th, I will not be available. I'll be.
Let it remain in the
11th
list 8th.
On 11th, my lord.
No, let it remain in the list on 8th of June. We'll see what is to be done.
Because if it is taken on 8th, my lord, I will be there, but on 9th and 10th, I will not. As your lordship.
Deeply obliged, my lord.
In item number
Lord,
3, I am for
Lord,
the
in the other matter, I have entered my appearance by Bhokalatama. In this matter, Lord, I also.
Please
Yes.
file your Wakalatnama. Leave granted. Which respondent?
The respondent number 227.
227?
at a Kaguz.
Leave granted to file Wakalatnama 227.
In item
Item
number 3,
3.
I am for the Union of India.
Lordship, item number 3, my senior for the petitioner is engaged another court. Kindly short pass over.
My lord, I have not yet received the instructions.
What is the matter about?
The matter about he has been given a medical test, but it was not successful. Here, there was a medical test. He applied for a job in the CRPF.
Oh, CRPF.
My lord, in this matter, I have.
You are appearing?
So, my lord, this the after my lord, this the examination, my lord, my medical examination.
Show your medical examination. You were given fitness certificate.
My lord, this the authority concerned has found that I am unfit.
Show me.
So, my lord, is kindly come to page 15.
14.
Kindly come to first, my lord, format of the physical standard test on Sergeant
Page
Session.
15.
1-5.
DME is page 14. Where is the review medical examination?
So, my lord, I approach before the authority concerned within the time, that is the page 42. So now this is the TTS, my lord, the review application, because of no format application is there, but I approach within the period of prescribed limit, my lords. So let them to authority be considered by treating.
I did not follow. Page 14, I can see the report of the detailed medical examination.
Lordship.
Please come. 15th of November 25.
Lordship. 15th of November.
This is the DME, right?
Yeah,
4 grounds for unfitness.
yes, yes.
You applied for the review.
Lordship, my lord, that is the last annex of page 42. So then I have collected the government college, my lord, the government medical college, and collected all the documents. So let them to take review.
The petitioner participated for recruitment in the CAPF examination, 2025. Stop. He was declared medically unfit by the DME board on 4 grounds. Copy the grounds, page 14. Stop. The report of the detailed medical examination contained a note that A dissatisfied candidate may apply for the review medical examination by signing on the consent form attached therewith. The review medical examination was due to be conducted on 17th of November 2025. Stop. The petitioner received the result of the medical examination on 15th November 2025 and he gave his consent for undergoing the review medical examination. Stop. For reasons best known, he did not appear for the review medical examination on the scheduled date and time, but he made a further representation on 4th December 2025 seeking for appearing in the review medical examination. Stop paragraph. Prayer has been made. Now, tarage. The said application not being considered, comma, the instant writ petition has been filed. Stop. Prayer has been made to direct the authority to consider his application permitting review medical examination. Stop. Upon hearing the submission made on behalf of the parties and on perusal of the documents annexed to the writ petition, comma, the court is of the opinion that the prayer of the petitioner cannot be allowed, as a specific date and time was mentioned by the authority for appearing in the review medical examination. Stop. The petitioner did not avail the opportunity granted to him to appear in the review medical examination. Stop. He made an application as per his own convenient time, seeking further review medical examination. Stop. A candidate in a public recruitment process is required to follow the date and time stipulated by the recruiting authority and cannot choose a date or a time for appearing in the examination. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant writ petition. The writ petition fails and is hereby dismissed.
Within 1 month. So I approached before the within 1 month. But I want that day, because of that, I lost the original copy. That's why I approached before the local police station. So the
next page. Next matter. Deeply obliged.
For the response.
226.
Is there an affidavit of service?
Yes.
My lord, petitioner was appointed, my lord, as my lord assistant manager in the post, my lord, in the year 1993. Thereafter, your petitioner was transferred from Bandel to Southaldi on 30th January 2012. My lord, in the meantime, petitioner was undergo treatment for his mental health, my lord. He was mental disorder, my lord. I have annexed the papers. My lord, from February 2012 to February 2019, he was unauthorized absent. Thereafter, he was reinstated in the post of clerk and started to getting salary, my lord. My lord, now the petitioner is claiming the arrears salaries.
Without doing any work, you expect salary to be given?
No proceeding has been initiated against the petitioner.
You thank your stars that they have recruited you back in service.
My lord, I know, my lord.
Then?
But no proceeding, nothing has been done, my lord. Straightway he has been reappointed, my lord. For this reason, my lord, he is claiming that.
Reappointed. Show me your reappointment letter.
My lord, I have, my lord, only annexed the salary slip from 2019. My lord, which it appears from, my lord, page
36, payslip, February 2019. Designation is assistant manager. Contract.
Lord, petitioner made several representation appearings from page 38.
Are you in perfect mental condition to perform your duties?
Treatment is going on.
Still treatment
Lord,
going on?
Yes, I have annexed the papers, my lord.
What type of work are you doing as an assistant manager with unhealthy mind?
My lord, now my lord, he is stable, my lord.
He is stable?
Certificate of the doctors, my lord, he joined. My lord, my representation is page 38 onwards.
What is your procedure?
Lordship,
Tell me, how did you permit him to join with absence for 6-7 years?
7 years.
we have not taken anything.
Lenient view was taken.
Lenient view has been taken.
And now this is the result.
And this is the bona fide act of the management has been projected by my learned defense client as a malafide one. Lordship, kindly take the trouble to consider only one thing. Page 37.
Yes.
What the instruction of my learned friend is, he has been made as a clerk. It is an incorrect one. He is an assistant manager PS, and if your lordship kindly consider, in 2019 his salary was 31,000. Now 2025 September he is getting 82,000, and he is not happy with that. He wants the
And he has mental illness.
And 12 to 19, he did not.
7 years.
7 years, he did not work. He was transferred from one place to another. He did not join. Nothing was there. Management, considering his
mental health issues.
That's why it has been done. Now, if he comes with this thing, Lordship,
file a report and you disclose your stand, your lenient stand taken, and how he wants to take advantage of the whole thing. All right. Should I dismiss now?
Even on record.
My lord, I am only praying, my lord. I know the fate of the case, my lord.
I even know that you know the fate.
My lord, I am only
82,000 is a fair, good amount for filing writ petitions. Right.
Let them consider my representation, then, my lord, it will. They will reject, my lord.
And again you will come.
No, no, no.
No, so better let them come over here, let the court pass an order so that I seal your fate. The petitioner is serving as assistant manager within bracket PS in the West Bengal Power Development Corporation Limited. Stop. He remained absent from duty for the years 2012 till 2019. (2012 to 2019).
Lordship, page 11, may subject to Lordship kind approval. Page 11 is the transfer order, release order, and page 13. Page 11 is the transfer order. Page 13 was the release order, Lordship. In 2012 itself, he did not join. Somehow.
And he came back to the old place and you permitted him to join. You all even don't maintain your own records.
Somehow leniency has been shown to the at the level of par excellence. Now,
there must be some reason as to why you were so lenient with that person.
I don't know. The thing is, after that, if he wants this,
he was transferred in January 2012. But he failed to join the transferred place of posting. Stop. Paragraph submission is that the petitioner was suffering from mental health issues and was not in a position to perform his duty. Stop. It is only in January 2019 that he joined. Stop. January and February 2019.
Lord, January joined, February is getting salary.
January 19 he joined.
February
2019. ঠিক আছে তাহলে he was absent হবে ওটা 2018 পর্যন্ত 12 to 18 হুম আচ্ছা paragraph submission of the petitioner is that the salary for the year 2012 till 2018 has not been paid to him. Stop prayer. Here, the petitioner made representation. Seeking disbursal of the salary for the aforesaid period. Stop. The same not being considered, comma, the instant writ petition has been filed. Paragraph. Learned advocate representing, learned senior counsel representing the West Bengal Power Development Corporation Limited submits upon instruction that the authority adopted an extremely lenient stand considering the health of the petitioner and permitted him to rejoin when he visited the office in the year 2019. Stop. The authority did not have as the petitioner did not perform his duty for the entire period from 2012 till the end of 2018, comma, the question of payment of salary does not arise at all. Stop. Paragraph. The petitioner is unable to produce any provision of law which permits grant of salary without performing any work. Stop. For the purpose of putting forth the stand of the authority as to how and why an employee who remained absent from duty was permitted to join. Absent for duty for six long years was permitted to rejoin. Let a report by way of affidavit be prepared and filed before this court. Stop. Can you do it by 2 weeks? No. Acha. Such a report by way of affidavit shall be prepared and circulated by 12th June. Release the matter on 22nd of June. Service is taken on record.
Grateful, man.
I'm for the response.
Bulky 1, subject matter of challenge, order of punishment passed by the discipline authority on 25th of June.
Who is the authority?
Chairman is the competent.
Chairman of?
Chairman WB.
West Bengal
Government.
Achha.
And the being agreed by with the order of the punishment, we've had an appeal before the board, which is the appellate authority. Appellate authority affirmed the order of the discipline authority.
This is the challenge.
That is the subject matter of challenge here.
All right, please come.
Only mandatory direction for
Affidavit. Achha. The petitioner being aggrieved by the order passed by the disciplinary authority, comma, affirmed by the appellate authority, has filed the instant writ petition. Stop. There is no scope for passing any interim order in this matter. Stop. The respondents are directed to file their affidavit in opposition within a period of 8 weeks. Reply, if any, within 3 weeks thereafter. 3 weeks thereafter. Liberty to mention the matter for hearing. Next.
6 minute, Mr. Kushal Chatterjee is appearing for the petitioner. But he is engaged in another courtroom. I'm praying for not this week.
So that. Yes, yesterday also
The same matter
thing
is going on in courtroom number 6, Milord.
All right. In that case, I place it in the next monthly list.
Kindly keep this matter, Milord, next week, Milord.
I'm raising the maintainability point with regard to the writ petition because in the earlier occasion, the petitioner was party on the writ petition, a WPST matter. My lord, I will produce the order of that writ petition. This is the second round of litigation challenging the same advertisement. The advertisement
for what?
Advertisement, they are saying that their Weimar sheet was Weimar sheet.
Is it
Answer
for
of the
recruitment, promotion, what?
recruitment
Recruitment process. Recruitment process of the year?
in 2018.
2018?
It was already decided, my lord. It is already decided by our division bench, lord.
So let that be heard out, Milord.
All right.
I'm raising the maintainability point of that.
All right. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. How many are there? One? Petitioners.
One petition.
Stop. Learned advocate representing you are the Public Service Commission. Raises an issue of maintainability of the writ petition. Stop. It has been submitted that the writ petition revolves around the recruitment process of the year 2018. Stop. The said process concluded long ago.
Yes.
Stop. There are decisions passed by this court.
Yes, coordinate bench of this court.
Regarding the said recruitment process. Stop. The issue which has been decided long ago has been sought to be re-agitated by way of the instant writ petition. Paragraph. The parties are directed to come prepared for hearing. List on 8th of June.
Grateful, lordship.
As your lordship, please.
Well, deficit, I'm raising a deficit court fees. There
How
are
many
lots
are
of
there?
petitions.
Lots of petitioners.
Yes.
Leave is granted to the advocate on record of the petitioners to deposit the deficit court fees. This week?
Milord, I'll have to take instructions on that. Milord, kindly give us 2 weeks, Milord.
Prior to the next date.
Yes, Milord. That is fair.
Next.
Grateful, lordship.
Yes, you are there.
I'm for the respondent.
The petitioner is challenging the order of removal from service after an ex parte disciplinary proceeding.
Ex parte disciplinary proceeding by?
By the Central Industrial Security Force.
CISF.
The petitioner was appointed.
And only the disciplinary proceeding and not the appellate authority's order?
Appellate authority order and thereafter mirrored the divisional authority order.
All three?
All three of them.
Very well. We aage ekta order dilam na. Affidavits direction.
In the meanwhile, Milord, I have one interim prayer, Milord. The petitioner is using the government accommodation, Milord. Since her services have been terminated, Milord, she is getting notices for eviction, Milord.
Obviously, terminated
12
stages.
notices were sent. 12.
Disciplinary authority, appellate authority, review authority. 3 places you lost. And High Court is going to give you stay or nothing.
My lord, 12 notices have been served. 12 notices she is not vacating.
Very well.
My lord, may I
Take
pray
steps.
for an order to vacate the premises to direct?
You take steps.
Indicate in the order. Kindly, my lord, indicate something in the order that we have issued 12 notices. In spite of that, she has not vacated the premises. She was allowed to occupy.
Stopping you from taking steps.
The pendency of the writ application will prevent us from issuing.
Why?
My lord knows that this is the highest judicial.
But before passing final order in the disciplinary proceeding,
The
Milord,
prayer
Milord, may I indicate
made
one
by the petitioner seeking stay of any proceeding with regard proceeding initiated by the authority
Milord,
to
no proceeding has been
no
proceeding has been initiated.
to take steps.
Milord,
To take steps for vacating the official residence.
Accommodation.
আচ্ছা accommodation কি দিয়ে শুরু করলাম the prayer for
আগেরটা বলতে হবে
is being disallowed by the court in view of the reason that the petitioner lost at 3 levels. Stop. No, semicolon. First before the disciplinary authority, comma, second before the appellate authority, and finally before the reviewing authority.
Revisional authority.
Revisional
Revisional
authority. ঠিক আছে?
Lord, may I indicate one?
Clear?
I am extremely good.
My Lord, may I indicate one thing? There is another writ petition filed by the same petitioner. My Lord, this was filed prior to the passing of the final order of removal. My Lord,
Give the
challenging.
number. So I'll
I'll
tag the matter
tag the matter.
together. Give the number.
But she has
Let
she has
the
undertaken
petition.
to withdraw that.
We have undertaken it to withdraw, my Lord, in this petition.
In
only.
case, give the number. I'll put it as to be mentioned, and it can be
It has
treated
been
as.
mentioned, my Lord, in my writ petition only that I'm
Give the number.
willing to
Give
withdraw.
the number. Give the number. To be mentioned. দিয়ে দেবেন তো? কাল বাদ পরশু. It is not there in the list.
No, my Lord.
All right.
It's a 2024 writ petition.
All right. It will appear in the list as to be mentioned, and this will be treated as withdrawn, disposed of, infructuous, whatever.
I am grateful.
Grateful.
I am for the petitioner. The matter is regarding of a state government employee as the SAT is not functioning. That is why the matter has been filed before your lordship. My lord, this is for hard cash benefit. Hard cash benefit of the petitioner. Everything gets revealed in page 127 where the representation is.
You want this representation to be considered?
Consider.
All right, please
that
come.
will suffice.
The petitioner prays for extending the benefit of the HUD CAS. Stop. A detailed representation by the petitioner. Where is the proof of service of this? By speed post you have mentioned 15th of September 2025. Where is the proof of service?
Proof of service, my lord.
Page 127 does not have the proof of service. And
Yes.
who is the authority to consider?
Authority is, my lord, 1 minute. Respondent number 3.
Who is
the
he?
authority.
Who is he?
The additional chief secretary, Department of Technical.
Why will the additional chief secretary take a decision with regard to the career advancement scheme? The director can take a decision.
Director.
তাহলে detailed লেখার দরকার নেই। Representation. A representation কি বললাম? By the petitioner addressed to the director, Directorate of Technical Education and Training. Submitted in July 2025 is pending consideration, is alleged to be pending consideration. Stop. Give me your service, please.
Yes, madam.
None appears on behalf of the state. Affidavit of service is on record. Stop. Paragraph. As it appears that the prayer of the petitioner for grant of grant of benefit under the career advancement scheme is pending consideration before the director. Accordingly, no useful purpose will be served by keeping the writ petition pending. Stop. The instant writ petition stands disposed of by directing the respondent number 2 to take a decision on the petitioner's prayer strictly in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. Step. If the prayer of the petitioner is allowed, the necessary consequential steps shall be taken by the authority without any further delay.
Opportunity for
Stop.
hearing.
Why? CAS, you want opportunity. Learned advocate for the petitioner is directed to forward a copy of the subject representation along with all supporting documents to the aforesaid authority at the time of communicating the order of the court. Disposal.
Obliged.
Service দিয়েছে?
In this matter, lordship, I am for the petitioner, lordship. That is the matter, lordship. The petitioner was the upper division clerk. He joined in 1969. He retired being the administrative officer in 2011. Thereafter, he prayed for the administrative officer's pay scale should be given to him. That was not granted by the authority till date. Kindly let the straightway come to page 20.
When you were serving, when you were in service, did you not make any representation?
So many
2011 and
so
we are
many-
in 26.
So many representation was made. So many matter was moved before this honorable court. Last of all, the Central Administrative Tribunal also order was passed. MA application filed. This was also considered. But Lordship may please to consider page 20 once for a moment.
20.
But the main issue was not decided. That is
Then go before the tribunal.
no,
Yes,
not necessary, Lordship. Not
Why?
kindly, Lordship. Lordship, consider come to
Where were you serving?
meteorological department, Lordship. Lordship, may please to come to
Meteorological department, will any grievance against that department be maintainable here under Article 226?
No, that's
Then
not.
why are you here?
There is no grievance against the writ petition to be filed before this honorable court. Lordship may please to consider three points. Lordship may please.
this is not the appropriate forum, my lord, as per my
Lordship.
knowledge, my lord.
Starts from page 20, Lordship. It is on 30th September 1997. Lordship may please to come to page 23.
Yes.
That the F column, Lordship. Administrative officer. Pay scale should be 7,500 to 12,000. Then Lordship may please to come to page 26. It was on 18th of August 2000. Notification on 1997, Lordship. Lordship, the Asit Kumar Patro, being the petitioner, is administrative officer, second line. 18th of August 2000, second line. Then Lordship may please to come to page. Thank you. Straightway come to Lordship. It starts from page 84, annexure P12. I am placing before your Lordship only the page 86.
Yes.
Lordship, I am reading this line only. Accordingly, in view of the above stated facts and the Gazette notification dated 30th September 1997, which is annexed in the page 20, issued by the Ministry of Finance and Honorable Supreme Court of India's order dated 13th July 2022, passed in SLP number such and such, confining the relief to Sri Purushottam Das, confining to relief to Sri Purushottam Das only. This is my grievance before you against the authority, that the one notification should not be passed for any judge, any personnel, any name only. That is the issue. But they are considering one order was passed by this court, that is the judgment in personnel, that should not be considered for this notification only. Notification for all the persons to be granted the relief. But they considered that as the judgment was passed for in personnel, that's why the notification is also considered being the personnel. That should not be. That is my grievance.
Yes.
Yeah. Then Lord,
and can this grievance be redressed by the writ court?
That has already been decided by this CAT, Lordship. That has already been decided by the.
So go before the CAT for execution of the order.
No, thereafter this was not considered being the issue relates to the notification, Lordship. That's why I am before your. Then Lordship, please to consider the next line. Lordship, please to consider the next line.
Page 67.
Lordship, please to come to page 67.
Next line of page 86.
No. They may not be. Consider the next line, Lordship. It is untenable to grant the benefit arising of the judgment order dated 18th of May 2015, passed by the Honorable High Court of Guwahati in WP number such and such, other administrative officers of the department. Thus, your request for the rectifications of granting of pre-revised pay scale of PV to such and such is not accepted. Then, Lordship, please to come to page 67.
Yes.
That is the order of this Central Administrative Tribunal. The present MA has been filed.
It has been complied with.
But.
What
that is-
but?
But that has not been complied with.
Go before CAT.
Yes, my lord. That is the appropriate forum, my lord.
But already that was decided. But the issue was.
No matter how much you stretch, you will not be able to get benefit. In this matter, please apply before the proper forum and get the benefit.
But the issue is this, Lordship, the Central Administrative Tribunal decided the issue relating to, kindly Lordship, consider the.
Assuming it has not decided correctly, then what is to be done? Prefer an appeal. You know what is to be done.
To see the proceeding is there.
Against the Central Administrative Tribunal order, I have filed this writ petition before this also.
Against Central Administrative Tribunal order, you have to approach division bench. How can you come before the single bench? There is a jurisdiction issue.
But it has already been decided by this honorable court also. One
You are
order was passed.
confusing yourself.
No, I'm not confusing myself.
Ashunta?
One order was also passed, Lordship, by this honorable court also.
10 orders may be passed by this court, but maybe by the WPCT bench. How can the writ petition single bench take up the matter? You try to understand things. Actually, the petitioner is a retired employee of the India Meteorological Department. Stop. He is aggrieved by the scale of pay according to which his payment was made. Stop. Paragraph. The court is of the opinion that any grievance against the said department cannot be adjudicated by the court under Article 226 of the Constitution as a court of first instance. Stop. The petitioner will be at liberty to approach the appropriate forum for relief in accordance with law if so advised. Writ petition dismissed. Yes.
Liberty to file, Lordship. Liberty has. Great.
My lord, 10 I am for the petitioner, my lord. Since that is the matter where petitioner is seeking appointment on a compassionate ground, my lord.
From whom?
My lord, from the forest department, my lord, for getting an appointment under the Group B post. My lord,
When did you apply?
My lord, I applied in the year 2022. Even in 2023, a committee was been formed by the department. But still that committee did not produce any report regarding the financial status of the.
Where is the application? Please show.
My lord, my representation is at page 26. This is a representation which petitioner's mother has given for getting the compassionate appointment for the petitioner.
Your father was an employee?
Yes, my father was an employee.
Please come. The father of the petitioner was employed in the Department of Forest.
In the post of Group D.
In the Group D post. Stop. He died in harness on 3rd of February 2022. Stop. An application seeking appointment on compassionate ground was filed by the petitioner. Stop. Though a 3-member screening cum inquiry committee was constituted for ascertaining the financial condition of the family of the deceased, deceased in July 2023, but the petitioner alleges that no further steps have been taken. Stop. Several representations were made by the petitioner, but there is no response to the same. Stop. None appears on behalf of the respondents. Stop. Affidavit of service is on record. Stop. As it appears that the petitioner's prayer seeking compassionate appointment is pending consideration before the respondent authority. Accordingly, the instant writ petition stands disposed of by directing the Principal Chief Conservator of Forests, to take a decision on the prayer made by the petitioner strictly in accordance with the prevailing rules at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The fate of the petitioner's application shall be made known to him. Stop. The authority shall keep in mind that appointment on compassionate ground is required to be considered on urgent basis, keeping in mind the financial need of the family of the deceased. Stop. আচ্ছা, যেখানে রিপ্রেজেন্টেশন দিয়েছে তার আগে একটা প্যারাগ্রাফ অ্যাড আপ করুন। The Chief Conservator of Forests, Southeast Circle, by a communication dated 10th August 2023, forwarded all relevant documents in connection with the prayer of the petitioner seeking appointment on compassionate ground to the Principal Chief Conservator of Forests and Head of Forests Force. তারপরে রিপ্রেজেন্টেশন। ঠিক আছে, disposed.
Yes, my lord, I am for the
I
petitioner.
before the response this matter.
The matter, my lord.
What happened yesterday?
My lord, I was on this, my lord. I was on Lex, my lord. That was, my lord, they informed me and immediately I rushed, my lord, to the court. And I was present, my lord, when your lordship has passed the order, my lord.
I couldn't see you.
No, I was.
Anyway, yes.
Your lordship had dismissed one matter and adjourned one matter, my lord.
My lord, this is the matter of balance provident fund dues of the employees.
All right.
My lord, petitioners.
11 petitioners?
Yes, my lord. Requisite court fee I will pay, my lord.
No, that is all right, but then everybody does not bear the same details.
Yes, my lord. Yes, my lord. Paragraph 23.
They have not made any
Page 16.
representation
Page
in the
16.
matter, my lord,
Page 16.
but they want, my lord, to get order.
23.
23, 24, page 16.
Hmm.
Page 16, the detailed diagram is there.
Yes.
How much they received,
Principal amount
how
is
much
such
they
an
received,
amount payable, such and such, received amount,
and
such
balance
such
amount.
balance amount.
Yes. As because it is the second round of litigation.
Here, my lord, they have not.
Where are the dates of retirement?
All are
Different dates.
2007 to 2011.
Right. So different dates and all the employees joined together in one writ petition.
Yes, my lord.
Why are you not paying the
My lord, here, my
provident
lord,
fund dues?
no, my lord, they have received, my lord, balance dues, my lord. We have not received from the NGMC, my lord, the full amount. Still, there are certain amounts, my lord, lying with them, my lord, but my lord,
held by the division bench and reiterated by this
Yes.
court in a similar matter. Kindly look into
yes,
the
your
order.
lordship has.
Lordship, the onus has.
Who are you?
Lordship,
National Jute Manufacturers.
Yes.
All right.
Lordship, pursuant to the order passed by the division bench, it is the incumbent provident fund which shall pay the dues and thereafter.
Did you pay the dues to the Provident Fund Authority?
Still, my lord,
No. Lordship, at every material point of time, the provident funds were managed by the board of trustees. And the only active participation.
Now, custodian of provident fund is
my
respondent
lord,
number 3.
that was a exempted establishment, my lord, under
It is
section
admitted
17 of
fact.
the act, my lord, after
All
cancellation
money,
of
all
exemption, my
money.
lord, they have not, my lord, deposited or submitted the past accumulations, my lord, in full.
All
There
money.
is still, my lord, some, my lord, more than.
See an order passed by this bench where your
Yes.
name is recorded. So same
Yeah,
order.
it's same order in accordance with law because there are so many, my lord, employees, my lord, in this rate petition. So they will take steps in accordance with law within a
When?
period of
At the stage of contempt.
within a
At the
period.
stage of contempt,
Within
they disburse.
within a period of 8 weeks. my
Not
lord.
in the
Your
normal.
lordship, on the last occasion, your lordship has also, my lord, given, my lord, 8 weeks time, my lord, this in this matter, and in accordance with we will.
Same order will go down.
That would be done.
And deficit court fees. When? Deficit court fees. By?
By Friday. By
Friday.
By Friday.
আচ্ছা। কোর্ট ফিস কি এই অর্ডার আপলোড না হলে কোর্ট ফিস জমা নেয় না? দেখুন তো যখন তখন এর জন্য তো অর্ডারের কোনো দরকার নেই তো। ফ্রাইডের ভেতরে জমা দেবে। You will take Friday? Today is only Tuesday.
Of
the order, yes.
Thursday, I have to communicate, then they will.
What communicate? I was in that side. I know how matters work.
My lord.
You will communicate, then the money will come and then you will pay.
No, my lord.
And the writ petition is being done pro bono. There are 11
then-
petitioners.
Then
2200
Thursday.
হ্যাঁ, সোমবার দিন এটা লিস্টে থাকবে as to be mentioned for ascertaining payment of court fees. You can try all this trick with somebody who doesn't know how the things function. But with someone who knows it, no use playing. All then matters. Next matter.
My lord, order would be passed, my lord, for a settlement of court fees, my lord, on Monday.
For ascertainment of court fees on Monday, but the order is passed today.
Great, lord. Great.
This order will be passed, signed,
That will not
uploaded,
That will
everything.
not be implemented.
I
my
have
lord,
to
unless, my lord,
comply. I have to comply. I will file.
Yes.
You
I will
will
file.
proceed with it, not that you get a leeway till Monday. No.
Yes, my lord. Grateful, yes. Okay.
Call. রাখুন।
My lord,
My lord, I beg to appear on behalf of the petitioner.
My lord, Mr. Manik Das appearing on behalf of the Eastern Coalfield, my lord. He is under medical treatment, so I'm praying for not this week, lordship.
Not this week.
Or after vacation, lordship.
After vacation, he is the petitioner. Try to understand.
Not this week, my lord.
What is your prayer?
My lord, my prayer is the compassionate appointment in alternative MMCC benefit. I am the widow daughter of the deceased employee. I am the only daughter of my deceased mother, who was an employee of the Eastern Coalfields Limited. He died long back, my lord, but thereafter I have been directed to appear before the
2019.
committee, and they remain mum over the matter. So,
Mr. Das cannot join online. No.
my lord, let
Monday.
let the direction be for report in the form of affidavit.
Why report it? I will dispose it up here and now. Your learned friend is not here. On Monday, please
Under
come.
medical treatment.
All right. Let him get well soon, but
Lots.
matter will be there on Monday.
Yes.
Lots. Much obliged.
Monday in the supplementary list. Dismissed. Any matter where the petitioner is not there, it will be dismissed.
See, madam, the respondent.
Affidavit?
No.
What? Disciplinary proceeding?
Subject to my lord, kind directed to my learned friend to submit a report.
Report?
A retired employee.
Yes.
Is dismissed from the service.
When?
2014.
Issue is not
Dismissal.
dismissal. What happened, my lord? He was dismissed from service. 1st April 2018, Bongio Gramin Vikas Bank service pension regulation came into force. Effective date was 1st April 2018. And in terms of the pension regulation 29, that if any employee is dismissed or removed from the service on or after the effective date, compassionate pension may be considered. Subsequently, in the year 2024, amended pension regulation, and effective date was 1st April 1993. Petitioner was dismissed in the year 2014.
Yes.
Made an application.
Show me that amendment notification.
My lord. This is second round of litigation.
All right.
Page 29, madam.
Page 29 or 32?
29 regulations
Is
start
the
from
Hindi portion and
32,
32 is proper in the Bongio such and such. First day of April figures such and
new
such.
amendment, madam.
New amendment.
2018 regulation is amended in 2024. Certain provisions are inserted in.
1 minute.
First day of November.
Application. An
1993.
application. In
shall be
regulation
subject.
3 of this said regulation.
And my lord, kindly
Where is the other one?
thereafter
2018 regulation?
2018 regulation, my lord, that was amended and effective date was amended 1st April 1993.
Let me see
He
once.
made an application.
2018 regulation, please show me once.
I'm coming.
Is it annexed?
No, no, it is not annexed one.
No, kindly have a look.
Will you be
Page-
covered by
Page
28?
35. He made an application
Yes.
which was rejected referring clause 29 of the pension regulation. Page 30. An employee who is dismissed or removed.
That order was set aside by the High Court.
This order, page 35.
Not set aside. It is set aside. My lord, regulation. It is hereby informed that your application for pension compassionate allowance has been rejected by the appellate authority in terms of regulation 29. What the regulation 29 speaks? An employee who is dismissed or removed or terminated from service shall forfeit his pension, provided that the authority higher than the authority competent to dismiss or remove or terminate him from service may, if such dismissal, removal, or termination is on or after the effective date, and the case is deserving of special condition. Rejected. Next page 36 is the order of the Honorable Court.
Yes, this has been set aside.
Yes, well, I am saying that. Thereafter, order passed by the bank.
Right.
And kindly have a look to the
And the court directed the authority to revisit the
Yes,
issue.
which is the subject matter of challenge in the writ petition.
Page,
Kindly have a
did-
look. Page
they
43.
revisited, madam.
Page
Page 43.
43 is the revisited order. What is the rejection this time?
My lord, the prior to that, point, kindly have a look to the order of the honor. What is the observation?
I have seen the observation. Yes, page 43. What does it say? And this has to be decided. Please come.
Kindly have a look for formation.
The order dated 22nd January 2026, passed by the Chief Manager within bracket HR, West Bengal Grameen Bank, rejecting the prayer of the petitioner for grant of compassionate pension
In terms of regulation 29.
is impugned in the instant writ petition. Stop. The issue in question has to be decided upon exchange of affidavits. Stop. Let affidavit in opposition be prepared and circulated by 12th June. Released on 26th of June.
My lord.
Reply may be filed prior to the adjourned date.
Let the matter be retained after the hearing.
After the, that is the reason I shortened the time. But if after affidavit the matters are retained for as motion, then the motion list will never proceed. 104.
Well,
item number 104, I am for the petition.
Yes.
The case, against the West Bengal Health Recruitment Board's notification. My lord, I am an OBC, a candidate, my lord. I have the certificate of 2009. My lord, in the matter of Amol Chandra Das, my lord, these OBC certificates were cancelled. That was from 2010 onwards. I have given my certificate, but my candidature was not accepted despite of that. My lord, that I'm.
What is the stage now?
My lord, the panel has been published. The second panel is going to be published soon. So, my
Yes.
lord, I'm today, my lord, they are not appearing. Their
Yes.
appearance is required, my lord.
Right.
My lord, kindly give some priority in this matter so that I can give the notice in the next week, any day, my lord. Kindly.
Next week also they won't come because request has been made for adjourning the matter for 2 weeks at least.
But after that, immediately after that, can it be placed, my lord?
আচ্ছা ঠিক আছে আসুন দেখি. The matter relates to a recruitment process conducted by the West Bengal Health Recruitment Board. Stop paragraph. The petitioner claims reservation relying on the reservation certificate, which was issued in her favor in the year 2009. Stop. Paragraph. The issue cannot be decided in the absence of the respondents. Stop. Let further notice be issued. Released on 19th of May.
Grateful.
Thank you, sir.
Lord, I am for the petitioner in this case, my lord. The petitioner by your lordship who is the married daughter of the deceased employee who was working under the fire services. My lord, after his death, his eldest deceased employee eldest had applied for the compensation, but his case was considered for non-submission of the documents. Thereafter, my lord, the married daughters applied for the compensation appointments, submitting the various documents, and thereafter, my lord, a letter was issued, which is at page 19, whereby the division fire officer has sent those documents to the higher authority. Thereafter, there are series of representation. Thereafter, after 19, if your lordship says, but today, my lord, I cannot pray for the ex parte order because of down appearance of the states, and my lord has decided. Even, my lord, I cannot pray before your lordship for consideration of the last representation. Which is
But then 2003 expiry.
Yes,
in
2003
2026, you seek compassionate appointment, still proceeding with your compassionate appointment claim.
kindly see the page 19. That's a very
Yes, page
important.
19 I have seen. The status report in respect of such and such fire station department now in place with inquiry office regarding requirement and compassionate.
Thereafter, there is a series of representation filed by the petitioner, which has not been responded back till today.
The employee died in 2003. And the application for appointment was made when?
In 2022.
22.
By the petitioner. 22 petitioner.
How is this maintainable?
But before that, the eldest son of the deceased employee applied for the appointment.
Yes.
But his case was not considered as because for non-submission of the documents,
right,
which was required.
Yes.
Thereafter, my lord, the petitioner before lordship has applied. She is a married daughter. Before that, so my lord,
So anybody can apply anytime for obtaining compassionate appointment.
for page 19, I am relying on page 19, which has been filed by which was.
Does page 19 give you an opportunity to get a job on compassionate ground?
No, I'm not, my lord. But by application, as per the page 19, below page 20, 21, 22, I am today, my lord, I'm not asking for the direct appointment, but let my representative, which has not.
Why will your representation be considered is the question.
Because in view of this page 19 of
So
the.
page 19 is nothing. Please come. The petitioner seeks compassionate appointment. Stop. She is a married daughter of an employee who was serving in the Department of Fire and Emergency Services. Stop. Her father expired. Died in harness on 3rd March 2003. Stop. The petitioner submits that his brother, that is the son of the deceased employee, applied for compassionate appointment, but as the same was not considered, the petitioner again applied for compassionate appointment in November 2022, followed up by representations in 2023. Stop. The authority, the Additional Director General, West Bengal Fire and Emergency Services, by communication dated 23rd June 2023, forwarded the application of the petitioner dated 17th November 2022 to the Divisional Forest Officer, South 24 Parganas Division, for collection of necessary documents from the petitioner. Stop. The Divisional Fire Officer by a communication dated 24th July 2023. Forwarded the status report of the petitioner's application to the Director General, along with necessary documents. Step. Allegation of the petitioner is that since thereafter, she has not been made aware of the fate of her application seeking compassionate appointment. Step. None represents the respondents. Step. Paragraph. Upon hearing the submission made on behalf of the petitioner and on perusal of the documents placed before this court, the court is of the opinion that compassionate appointment cannot be claimed as a matter of right. Step. The same is to be considered for tiding over the immediate financial crisis faced on the death of the bread earner. Step. In the instant case, the employee expired in March 2003. Step. The petitioner applied for compassionate appointment in November 2022. Stop. The authority, failed to appreciate the urgency and the necessity for considering an application seeking compassionate appointment made after decades of the death of the employee. Nearly 2 decades, 2003, 13, 23. Achha, kore din apni 19 years. Stop. The prayer of the petitioner seeking a direction upon the authority to dispose of her prayer. An application seeking appointment on compassionate ground cannot be considered, cannot be allowed, as as at such a belated point of time, there is hardly any scope to show compassion to the heir of the deceased. Stop. Had the petitioner been in financial crisis, then application for compassionate appointment ought to have been made immediately after the death of the employee. Stop. Such belated claim seeking appointment on compassionate ground does not merit consideration. The writ petition fails and is hereby dismissed.
Great.
Lordship, I am appearing on behalf of the petitioner.
For CSTC led by Mr. Vianney, Lordship. He is on legs.
Petitioner is a retired employee of Calcutta State Transport Corporation, Your Lordship. Your Lordship retired from service on 31st of October 2024 as depot manager of CSTC, Your Lordship. Your Lordship, he was covered under the Contributory Provident Fund, but he was not covered under the CPF. He was a CPF holder, Your Lordship. He did not opt for pension under DCRB, so he is a member of EPS 95, that is Employees Provident Fund Scheme 1995. So he's as a member of EPS 95, he's entitled to higher pension, but not the pension under DCRB. That was option oriented. That I am not on that. I am an EPS member, so I am entitled to get the higher pension. After my retirement, Your Lordship, the demand notice was issued in favor of me on 24th of July 2024. Dated, this demand letter was given to me asking for a refund of rupees 24 lakhs and odd from me, Your Lordship. But Your Lordship, the thing is that after my retirement, I did not even pay my provident fund. So I requested the authority to get the...
See, please come to page 39. There is already an order in your favor directing the authority to release the residual 80% of the CPF dues.
So they sent me a demand notice that you deposit this amount to get higher pension. I made a representation that you get it from CSTC because my provident fund is due. Your Lordship, they did not pay any heed to my representation. Then I came before before this honorable court praying for payment of my provident fund. So this honorable court directed them to pay my provident fund. In compliance of that, Your Lordship, the provident fund was paid to me. So I am getting I got my provident fund with interest. So that is admitted facts. Now I am requesting the Employees Provident Fund Organization allow me to deposit the amount, but they are not allowing me to do so.
Which amount?
This 24 lakhs and odd, which they had sent a demand notice.
Where
to
is
Your
the
Lordship.
demand? Where is
Page
the
28? Page 28, Annexure P4. The demand notice was sent to me by the Employees Provident Fund Organization Regional Office, Barrackpur. Well, P4, page 28. The amount is, my lord, kindly see the last bottom part. 25 lakhs.
Did you serve the
Lordship.
EPF authority?
Yes, yes, Your Lordship.
Mr. Shivchandra Prasad was here just now. Just call him, he appears for the authority.
Lordship, here my prayer is only just allow me to deposit this amount.
Call him, call him. Pass over.
Number 107, Your Lordship, I am praying for the petitioner. Your Lordship, here the petition is a retired employee of the Calcutta State Transport Corporation. He retired on 31st of August 2025. He is covered under General Provident Fund. So GPF, Your Lordship, the whole contribution is his contribution. But Your Lordship, they have not disbursed a single penny towards my Provident Fund due till date. So my prayer before Your Lordship to disburse 100% of my Provident Fund with interest, and one more prayer before Your Lordship, that as I am a GPF holder, Your Lordship, I am entitled to get my DA in my pensionable gratuity. If my lord will come to Annexure P3, page number 21, with reference to the above, I am directed to inform that while calculating the amount of death retirement gratuity, the monthly emoluments shall include basic P and DA. Your Lordship, next page, Your Lordship, kindly come to page P4, page 22. My lord, with reference to the above, I am directed to inform you that the Finance Department has conveyed their observation as follows. The date of effect of the revised definition of the monthly emoluments while calculating retirement death gratuity may be considered from 1/1/2016 in the best interest of the employees of the CSTC. If the employees of CSTC are covered under the payment of gratuity and anti-70, the admissible gratuity shall be settled following the relevant provisions of the Act. So, Your Lordship, in this respect, in this issue, particular issue, Your Lordship, my lord's order is there. My lord's order, that I am entitled to get my DA in my pensionable gratuity. I have handed over the copy to my learned friend, Your Lordship. This is my lord's order.
This one, the order that you are relying upon, there the petitioners were receiving their regular pension. Here, are you getting your pension?
Lordship.
This you are getting.
Lordship, only in terms of the pensionable gratuity, I am entitled to get my DA. The DA to be
So
included.
the issue is only the DA over here.
Lordship, DA and the 100% payment of 100% of my Provident Fund. Because
Yes.
I have not received my Provident Fund till date.
Nothing.
Lordship, nothing. So twofold prayers. I am a GPF holder, so I am getting my monthly pension.
Where is the EPF authority a party in this matter?
Lordship, in this matter, Calcutta State Transport Corporation Employees Provident Fund. 6. Respondent, Calcutta State Transport Corporation Employees Provident Fund Trust.
It is a trust.
Trust.
It is not the Employees Provident Fund organization.
No, no.
This is a
CSTC,
trust.
yes.
CSTC has its own trust.
Lordship.
Oh, in the other matter, then I thought it was the organization.
Lordship, the earlier matter is different matter.
Oh, it's different.
It's a different. This is the thing. This trust
This
has
will
to
be,
disburse this provident fund.
you will be representing the trust also?
Lordship, for the trust, Lordship, a different person is appearing.
But
How
Your
come?
Lordship, the other matters, Your Lordship,
How come the trust is represented by somebody else? It is your trust?
No.
You all do not represent the trust. The employees, the state transport, Calcutta State Transport employees,
Yes.
Provident Fund Trust, you all do not.
No, but trust is represented by different.
Somebody who represents the trust?
Possibly, Mr. Niladri Bhattacharya used to appear in some matters. I have seen that. Because even in contempt, my lord, Mr. Bhattacharya had appeared separately. So I cannot represent the trust. The fund collected by the CSTC goes to the trust.
Right.
Therefore-
Now a direction is to be passed upon the respondent number 6 trust. So their presence will be required.
same with DA Mamla or 100% provident fund.
There are two prayers. One prayer can be disposed of because it is already decided in this matter. But the he has not got the provident fund dues at all. Acha, please come. এটা এখানে বলা আছে petitioner is a retired employee of the
There is, I'm sorry, there is possibly a.
Yes, there is possibly.
জজসাহেবের অর্ডারটা দিয়েছে
সেটাই তো, the lordship's order.
এর ইস্যু
Look, there are another.
Yes.
That is the DA issue decided, same order can be passed, but the trust, the petitioner has not received the employees' provident fund deposit at all.
Then they should appear and clarify.
What is the clarification? He has retired. It has to be paid. If somebody doesn't come, why will the retired employee suffer?
No, should not. Actually, sorry, the key over.
Acha. He alleges non-payment. No, he is a general provident fund opti, and he is supposed to receive his provident fund dues from the respondent number 6, Calcutta State Transport Corporation Employees Provident Fund Trust. Yeah. Stop. কি দিয়ে শুরু করেছিলাম সেন্টেন্সটা? He is a GPF of T. তাই তো? দেখুন, allegation is that after his retirement on 31st August 2025, he did not receive his provident fund dues at all. Stop. He further alleges that the pension that he is receiving does not include the dearness component, dearness allowance component. Stop. Paragraph. The issue regarding applicability of the dearness allowance in the pensionable gratuity paid to the retired employees of the organization has been decided by the court decided by the court on 31st March 2026 in WPA such and such. Stop. The petitioner relies upon the said order and prays for similar relief. ঠিক আছে? In Proshun Talukdar and others within bracket Supra, the court held that in terms of the several memo relied upon, not relied upon, memo of the Transport Department, Government of West Bengal, the retired employees would be entitled to receive the gratuity and pension including the dearness allowance. Stop. The court directed the authority to take steps and directed the managing director of the Calcutta State Transport Corporation to take steps for disbursing the dearness allowance component to the retired employees in terms of the memoranda dated 14th September 2025, 4th September 2025 and 14th January 2026. ঠিক আছে? Stop. আচ্ছা। As the issue has already been decided in the matter of Proshun Talukdar and others supra, accordingly the instant writ petition stands disposed of. In the same lines, directing the managing director, CSTC to take steps for disbursing the DNS allowance component to the petitioner in terms of the aforesaid memoranda at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. As the petitioner retired way back in August 2025, he would be entitled to receive his Provident Fund dues, which was deposited by him. Stop. The respondent number 6 is directed to release the Provident Fund dues of the petitioner without any further delay, but positively within a period of 12 weeks from the date of communication of this order. Stop. As the petitioner would be receiving his Provident Fund dues after considerable delay, the said dues shall be accompanied with simple interest calculated at the rate of 6% per annum. On and from the due date. Now, on and from the next date of retirement till the date of actual payment. Stop. In the event the Provident Fund dues is not cleared within the time limit stipulated herein above, then additional 2% simple interest shall be payable to the petitioner. That is 6 plus 2, 8% simple interest. On and from the next date of retirement till the date of actual payment. Disposed.
Only one thing, my lord, possibly there's nothing else, absolutely, but only one thing, since the normally it should be always the interest should be from the date of retirement in case of delay. Only thing, my lord, I find from here that the explanation from the state government as to the date of effect has come later.
When?
It has come on the 14th of January 2026. The explanation.
No, this is for the dearness allowance, no interest
Not
is
from the
paid.
dearness allowance, for the Provident Fund.
Provident Fund is to be paid on and from the next date of retirement.
Oh, bhulval hoega, chalo, Lordship will explain. So many matters she has filed, everything has got jumbled up. Provident, dearness. না এটা ডিএনএ প্রভিডেন্ট এটা কোন মামলা ভাই
এরপরে হ্যাঁ 108
এটা কোনটা
Your Lordship 108 সৌম্য বলে দেবে
Your prayer only. Do not go to the introduction.
Retired from service on 30th of November 2025.
কি বিপদ রে ভাই
He received 20% of his provident fund belatedly. Now his prayer before your lordship is
80%?
80% of his provident fund
And interest. Gratuity not
along with
paid.
interest, gratuity not paid, and leave salary also paid belatedly.
All right. So 80% PF. Yesterday similar orders were passed.
Lordship
80% PF, gratuity not paid.
not paid, and interest on delayed payment of his leave salary.
Salary, leave salary you got.
Paid.
Acha. Leave salary interest.
Lordship.
Ashwin. The petitioner is a retired employee of the Calcutta State Transport Corporation. Stop. He retired from service on attaining his normal age of superannuation on 30th of November 2025. Stop. Allegation is that he has been paid only 20% of his provident fund dues and stop colon. He has not been paid his gratuity amount. Stop. He received his leave salary encashment at a delayed point of time. Prayer has been made to pay the balance provident fund dues, comma, the gratuity amount and interest on the delayed payment of the leave encashment. Stop. The dues claimed by the petitioner are all statutory dues and are required to be paid immediately on retirement of the employee or soon thereafter. Stop. The petitioner retired from service on 30th November 2025, but his dues have not been paid till date. Paragraph. In view of the above, the instant writ petition stands disposed of by directing the Managing Director of Calcutta State Transport Corporation to take steps for releasing the balance 80% provident fund dues of the petitioner, comma, his gratuity in full and the interest on account of delayed payment of leave encashment. Stop. As the petitioner, না কি বললাম এটা
সেটাও ঠিক তাহলে ওরও হবে না তোরও হবে আমারও হবে না আমরাও আটকে রাখে যে দেবেন না তাহলে মামলা করবো
gratuity in full at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. As the petitioner will be receiving his terminal dues after some delay, comma, accordingly, the amount due to him shall be accompanied with interest, simple interest, at the rate of 6% per annum, calculated on and from the next date of retirement till the date of actual payment. Stop. If 2% additional interest বললাম না আগের মামলাটাতে আচ্ছা ওটা if the aforesaid amount is not if the due amount of the petitioner is not disbursed within the time limit stipulated herein above, comma, then additional 2% interest, that is 6 plus 2 8% interest shall be payable to the petitioner. Disposed.
Now, may I make one submission?
Service
In
taken
the
on
other
record.
matters, if your lordship considers that I am here, even if I am not here. Deeply obliged. Lordship.
Same.
Same means 80%.
80% and gratuity, 80% PF gratuity and interest on leave salary. And the
All right.
retirement date is also same, 30th of November 2025.
All right.
109.
Same as 108.
My lord, 100. My lord, 109, your lordship. I'm sorry, your lordship. 109. One more thing, your lordship, is to be added. Here the petitioner retired from 30th of November 25 He has not received 80% of his PF, gratuity and leave salary also not received. 109. I'm sorry, Your Lordship. 109.
আগের ফাইলটা দেখি। Please make proper submission because the court is not looking at the papers.
Lordship, I do understand. I'm
His
sorry, Lord.
court is absolutely relying upon the submission that the petitioner is making.
Lordship.
Thereafter, if you come for correction, I will impose heavy cost. Keep this in mind.
No, Lordship. Lordship.
80% PF dues.
Hmm. Hmm.
Leave encashment not received.
Hmm. Gratuity not paid.
10 একদম
Date of retirement is the same.
30/11/25.
আগেরটাতে বলেছিলাম লিভ এনক্যাশমেন্ট পে করা হয়েছিল এট a delayed point of time. এখানে বলবেন not paid. Gratuity not paid. ঠিক আছে? Yes, 110.
My junior will do this, Your Lordship.
Lordship, in this
Madhur
matter,
Bhattacharya. Yes.
so this is similar to item number 108.
Retirement date of
108. Listen, I have forgotten. What is there in 108? Tell me.
Lordship, in this matter, the petitioner received
Date of retirement, tell me.
31/10/2025.
31st October 25. Yes. Then
Petitioner received 20%.
20% PF.
PF,
That means 80% is due.
80% is due,
Then
and he did not receive gratuity.
gratuity not received at all.
And
Yes.
he received leave salary, but no
Delayed
inter-
point of time.
belated.
All right. Same as 108. একটু বলে দেবেন তো ওখানে প্রদীপ নিয়েছে বোধহয় 108 দেখুন তাহলে ঠিক আছে yes
Lordship, in this matter, the petitioner is covered under the General Provident Fund,
yes
and he did not receive 100% PF. So I'm paying for 100% PF with statutory interest.
respondent number 6 date of retirement
28/2/2025.
28th of February 25 GPF not received at all
At all.
only prayer
Only prayer is 100% PF with statutory interest.
the petitioner retired from service on 28th February 2025. Stop. Allegation is that he has not been paid his provident fund dues. Stop. Prayer has been made to direct his employer, comma, Calcutta State Transport Corporation, comma, to disburse his terminal dues of provident fund along with interest. Stop. As the petitioner has retired more than a year back and has not been paid his provident fund dues, comma, the same ought to be paid to the petitioner without any further delay. Stop. Paragraph. As the petitioner will be receiving his statutory dues after considerable delay, comma, accordingly, the same shall be paid along with interest. Stop. Paragraph. The instant writ petition stands disposed of by directing the respondent number 6, CSTC Employees Provident Fund Trust, to disburse the provident fund dues of the petitioner in its entirety, along with simple interest at the rate of 6%. To be calculated on and from the next date of retirement till the date of actual payment. At the earliest, but positively within a period of 12 weeks from the date of communication of this order. In default, 2%. Disposed. পরেরটা বলুন তো
So this matter is similar to the previous one. The retirement is on 31/5/2025. 31 May 2025.
31st May 25. Only PF dues. Same as 111. Disposed. Palash Babu. Palash Babu. None for the respondent number 6. আগেরটাতে এইটাতে প্রতিটাতেই respondent number 6. Provident Fund, Provident Fund Authority. Where is your service? You've served the PF authority? Where is the service upon the respondent number 6?
Well, what happens, the CSTC is a CSTC's own trust, your lordship. So the Provident Fund Nilganj Depot, the address is the Nilganj Depot, but the copy is to be served before the managing director. 2 copies has to be served over there, your lordship, before the managing director. One is
How does the court know that you have served 2 copies? You have mentioned a copy of the writ petition?
No, your lordship, it should be the copies of the writ petition along with that.
Where is it?
2 copies is to be served before the managing director. This is the usual practice because CSTC is having their own trust. So office is at Nilganj, but the CSTC Poribam Bhavan is to be served with the.
Your affidavit of service says that I have served upon the respondent numbers 1 and 2. There is nothing mentioned upon the respondent number 6.
Lordship.
Then?
Lordship, but it has to be served upon them only, your lordship, because this is their own trust. So that
maybe the trust is represented by somebody else. It is not that CSTC authority is receiving.
Yes, your lordship, that is so, but after
But then
that,
I
this
am not
behind-
satisfied with the service. আচ্ছা আগের গুলো তো সেম করবেন যে there is no proof of service upon the respondent number 6. Stop. Let সবগুলোতেই let a copy of the writ petition be served along with a copy of this order.
Lordship, I will do it again.
ঠিক আছে বিদ্যুৎ কুমার বাসু এটা কি হয়ে গেল 113 না 112? Yes, বিদ্যুৎ কুমার বাসু, what is it?
Actually, the petition, same matter, the petitioner retired from service on 31/5/2025.
Yes.
And he did not receive any provident fund. So I'm paying for
Only GPF?
GPF.
All right, same as 101, 111.
111, 112, same.
Disposed.
So this matter is also same, my lord. The retirement is on 31/5/2025. Is covered under General Provident Fund, and I'm paying for 100% Provident Fund with statutory interest.
All right. Disposed.
Yes.
Yes. আশা করি advocate তো নেই advocate নেই nobody is there
For the petition. This is my petition of service.
What is your prayer?
Quashing of the charge sheet and allow me to rejoin in the service on the ground of
Quashing of
delay. 2018, the charge sheet was issued. Thereafter, I was informed to appear before the inquiry officer. Thereafter, they did not do anything, and the
Who
inquiry
is the employer?
employs the West Bengal Department of Health and Family Welfare.
Then you have to wait. None for the respondents. Affidavit of service is on record. Stop. Let further notice be issued. Released on 8th of June.
Lord, may I come back any day prior to this vacation, because the petitioner is going to be retired on January 27.
Well, then you cannot get the
May I
respondents.
get a chance to come back any day before the vacation?
No use. The panel is not there. Problem is this. Otherwise, the matter is there in the list and I'm taking it up. Had anybody been there, I could have taken up. Yes, next.
I'm good.
For the petition.
My lord, in 116, Mr. Krishnendu Bhattacharya is appearing on behalf of the ECL. My lord, upon his instruction, I have received that we have not received any information or report from ECL regarding this matter. My lord, kindly adjourn this matter for 2 weeks. We'll come back after.
I am objecting.
1 minute. The writ petition was filed in March, right? We are in May. When was it served?
My lord, I have
Give
no
me your
instructions
service.
regarding-
19 March.
See? And we are in May.
It is unserviced.
Expect the court is going to adjourn only in your prayer.
My lord, I'm upon instructions, lordship.
I understand that you are up on instruction, but the petitioner is here. Let me understand what the matter is, then I'll see what is to be done.
That is a disciplinary authority passed order of dismissal.
Dismissal?
Dismissal.
Then nothing doing.
then, my lord,
Did you
we have
file any appeal?
Appeal affirming the order of this authority. There is no question of
Interim order. Please come. The petitioner
only I am praying, my lord, only one.
was an employee of the Eastern Coalfields Limited. Stop. A departmental proceeding was initiated against him and he has been dismissed from service by the disciplinary authority. Stop. The appellate authority affirmed the said order of dismissal. Stop. Challenging the same, the petitioner has filed the instant writ petition. Stop. Paragraph. There is hardly any scope for passing any interim order in this matter at this stage. Stop. The respondents are directed to file their
Kindly specific the date.
affidavit in opposition within a period of 8 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing immediately on conclusion of the aforesaid time period. What is your name?
Amandeep Gupta.
Onar naamta likhe deben to. Amandeep Gupta. Yes, next.
Grateful, your lordship.
For the petitioner.
Yes.
The disciplinary proceeding was initiated against the petitioner in the year 2013, lordship. It got dropped in the year 2022, lordship. In the meantime, the petitioner retired in the year 2014. Pension benefits has been given. The difficulty is no interest has been given.
When was the interest given?
Never
Pension.
given. Pension given in the year 2024, but no interest has been given.
So
Till
you want
2024.
interest?
I want the
And
interest.
the delayed payment.
Delayed payment, lordship.
Then
I have moved before the SAT, lordship, in the.
It's not a matter of SAT. Thing is, the proceedings to dropped in 2022.
Lordship.
And you got the interest dues when?
2024, lordship. It was
24.
pension payment order was issued in the year 2023, and there are ADR pay and allowances in the year 2024. There are what I made representation before the authorities in the year 2024 itself, lordship. 26 that is there in page number 33, lordship.
But from 10 you cannot get the interest.
There is
Disciplinary proceeding was there against you.
lordship.
The proceedings to dropped only in the year 2022. As long as the proceeding was pending, you could not have received any terminal dues.
No, lordship.
Isn't it?
Lordship, thereafter I have challenged the order inaction before on the part of the department. Lordship, I have filed one OA, lordship. There the OA has directed to pay 6%. but they have
Show
not
me
paid
that order.
the page number 36, Lordship, after consideration of my representation to pay 6%. That is at page 36.
All right. After this order,
After challenging this order, I have filed one ST, Lordship, on the ground of 6%.
challenging this order,
On the ground of 6%, Lordship.
how much you want?
I want, Lordship, 18%. But this honorable court,
18%.
has granted 10%, Lordship. If there can be granted, Lordship, in a division bench.
10%. No, challenging this order passed in the original application. Did you prefer?
Preferred an appeal, Lordship. That is at page number 38, Lordship.
What is the order?
This honorable court had remanded the matter to the authorities on a to consider it and appropriate interfere with the order dated other. Make it clear that the issue of interest shall remain open to be agitated in accordance with law for any date which the petitioner may be able to substantiate before the authorities in accordance with law.
So no interference.
No interference, Lordship.
Petition dismissed. Then what happened?
Thereafter, I have made the representation before the authority. Page number 40, Lordship.
Yes.
Till date, they have not taken any action. That is the difficulty, Lordship. Since 2024, we are now in.
Then you actually want compliance of the direction passed by the tribunal.
I want enhancement of the interest, Lordship.
How can your prayer for enhancement has been dismissed, disallowed?
Lordship, they have yes, Lordship, but I have prayed for this honorable court has granted me leave to pay before the authority, Lordship.
Yes. The court categorically mentioned
issue of interest shall remain open, Lordship.
So let them take a decision.
They are not taking any decision. That is the difficulty, Lordship.
That means you want a decision to be taken in terms of the tribunal's order.
Yes, Your Lordship. A time frame maybe can be fixed, Lordship.
How many times the time will be framed? The tribunal already framed a time.
They are not taking any action,
Then?
Lordship. The petitioner is a 72-year-old person, Lordship.
The petitioner claims interest on account of delayed payment of his terminal dues. Stop paragraph. It appears that the petitioner approached the West Bengal Administrative Tribunal with his prayer in OA 5/8 of 2025, which stood disposed of on 3rd April 2025, directing the Block Development Officer, Itahar, Uttar Dinajpur, to consider the petitioner's representation. And if after examination of the records, the authority is satisfied that due to laches on their part, the terminal dues could not be released on proper time, then suitable action for awarding interest at the rate of 6 period for the period during which such payment was delayed was passed. Step. The tribunal directed the authority to conclude the process within a period of 3 months from the date of communication of the order. Paragraph. Challenging the order passed by the learned tribunal, the petitioner preferred a writ petition before this court, being WP ST 169 of 2025, which stood dismissed Video order dated 12th November 2025. Stop. The petitioner made further representation before the authority in December 2025 and alleges that the order of the tribunal has not been complied till date. Tell me one thing, the order was passed by the tribunal in April 2025. Did you communicate this order?
Yes, Your Lordship. That I don't have it with Lordship. I don't have it with me now, Lordship, but I have communicated, Lordship.
There is nothing to prove
Nothing
that
to
you communicated this order. Paragraph none appears on behalf of the respondents. Let further notice be issued upon the learned advocate representing the state respondents and on the block development officer, Itahar, Uttar Dinajpur. Stop. A report shall be prepared by the block development officer and circulated, not circulated, and served upon the learned advocate representing the petitioner by 12th June 2026. Release the matter on 16th June 2026. Stop. Learned বললাম না communicate করতে বললাম না ঠিক আছে service is taken on record. Please take this back.
The opposite party appeared before the OL, before the tribunal, Lordship.
I have seen his name also. That does not mean that you are not going to communicate the order.
Lordship, grateful, Lordship.
Please, Your Lordship. Due to my lord non-function of the tribunal, we beg to my lord move before this honorable court. A matter, my lord, the petitioner's father was working in a government press, Dalipur, and petitioner is seeking my lord in appointment on compassionate ground.
When did your father die?
Father, my lord, died in 2008. Within 2 years, the petitioner, my lord, filed his application. Thereafter, another one in prescribed format. After direction of the authority, we have further second application in prescribed format and filed.
When?
It was filed in again 2013. Page, my lord. Yes. First, my lord, we have filed, my lord, 28th of July 2010, within 2 years. Then again, we further application made, my lord, page 29 of the application, prescribed format in 2014. Yes. Page 29. First application is at, my lord, page 28. Died September 8, applied July 2010. Then next one, this prescribed format as per direction 29.
As per direction means what? Where is
well, the office superintendent office said that we have to again file this into prescribed format. That the second application was filed.
There is nothing to show that the office told you.
Well, that has been, my lord, we can, my lord, appraise the lordship that authority has accepted that part, but the ultimately
What
the.
are you going to say accepted?
My lord, kindly, my lord, then my lord, kindly says, my lord. Page 36.
Yes.
Yes. The understanding is this is from the OSD, Deputy Secretary to the government, to the Superintendent West Bengal Government Press. The understanding is directed to inform you that the proposal for appointment on compassionate in Inspector Sri Sujoy Kumar Sharma.
Yes, you have crossed the time limit, so it has been rejected.
Yes. Yes,
Then?
for this. My lord, next, my lord, this answer lies at page 37.
Yes.
Superintendent has clarified to the OSD, saying, my lord, late Chandan Sharma, ex-compositor of establishment, expired on such and such. Mr. Lalmati Devi, dependent wife of Sharma, submitted an application of employment of her dependent son, right? Office memo number 28th of July 2010. along with the pro forma regarding circular such and such. The payment of family pension and death gratuity are delayed due to approval of pay scale and pay of late Chandraswar Sharma from Finance Department. As such, file for employment on compassionate ground of cannot be processed and submitted in due time to the competent authority. Now, the copy of the application and pro forma regarding employment submitted within 2 years from the date of death are enclosed for your kind perusal and necessary action. So, my lord, that the delayed, what the ground was taken by the authority is not attributed to me. Next, my lord, page 38. Again, my lord, that has been accepted and OSD, my lord, sought for these documents. It says the undersigned to return here with the proposal for appointment on compassionate ground in respect to such and my lord, this petitioner, and to request him to kindly to resubmit the application with proper clarification of the following details. These were the 4 points sought. Next, my lord, this order in 2023, where it is again from the Deputy Secretary with reference to his letter number 1641 on the subject mentioned above. The undersigned is to request him to furnish the proposal of phrase with specific report of inquiry committee in original and decision of the appointing authority in this matter, along with original copy of Annexure A and affidavit on stamp paper from first class judicial magistrate regarding no objection and other dependent family members. Again, my lord, page 40. Again, a letter, my lord, situation, my lord, from the superintendent. It has been specifically clarified that the 4 points sought, these are the 1, 2, 3, 4 that was submitted before the authority and requested to proceed with. However, and my lord, just may I skip the next page for once, may I with a beg to my lord come back once again. The
Please show me
my
clause
lord, screening
10.
committee, my lord, called me.
Please come to page 42 and show
Yes.
this EMP.
Yes, EMP is at page 57. 42, my lord, kindly just sees, my lord, sees the date for once. The decision is taken in on, my lord, 21st of December 2023, saying only the EMP of 2013. It is at page 57. But the amendment to that, which was, my lord, came into effect in 2016, that was not considered. 57, the EMP, the first EMP is at starting from page 48. The relevant provision 10A, page 52. It says 10A, if the family of the deceased or the employee retired on being permanently incapacitated is in need of financial assistance and the same is absolutely necessary to support the family, application for employment is to be submitted within 6 months from the date of death.
Admittedly, the person expired in 2008.
8.
In 2026, why will your prayer be considered by the court?
My lord, it is, my lord, altogether, my lord, the authority ultimately in 2023, it was altogether under process, but in 2023, page 42 was.
Please come.
And my lord, the amendment provision is at page, my lord, 57, which says it is up, it may go up to 5 years also backlog.
Petitioner claims compassionate appointment. Stop. His father, his or her, his father died in harness on,
my lord, 10th of September 2008.
10 September 2008. Stop. An application seeking compassionate appointment. And application seeking compassionate appointment was filed by the petitioner. Petitioner by the widow of the deceased.
Yes.
In July 2010. Stop. An application in the prescribed format by the petitioner was submitted on
My lord, page 29, bottom. 13th November
13th of
2014.
November 2014. Stop. The same was initially considered by the authority and rejected. Wide communication dated 14th of June 2016 on the ground that the application was submitted by the petitioner beyond the stipulated time period. Stop. The superintendent of the government press, West Bengal, where the father of the petitioner was serving, communicated to the OSD and EO, Deputy Secretary to the Government of West Bengal, Commerce and Industries Department, that the application was made within the 2 years time period, but the file could not be processed within the due time as the pay scale of the deceased was not approved. Stop. The matter was thereafter again considered by the authority, and video communication dated 21st December 2023, the application stood rejected, relying upon clause 10 within brackets small a, double a, the AA, and clause 10 within brackets small a, 1a. Acta A of the Labor Department's notification number 251-EMP dated 3rd December 2013. Stop. Learned advocate for the petitioner submits that the petitioner was no way responsible for the delay on the part of the authority in considering the application seeking compassionate appointment. Stop. It has been contended that as the application was made within the stipulated time period of 2 years, the said application ought not to be rejected on the ground of delay. Stop. There was no delay and or laches on the part of the petitioner in either applying or processing his claim for compassionate appointment. Stop. Prayer has been made to set aside the impugned order of rejection and to direct the authority to reconsider the application and issue appointment, not issue, grant compassionate appointment to the petitioner. Stop. Paragraph. And appears on behalf of the respondent.
Page 56, my lord, the amendment must be taken into consideration, which says it may go up to 5 years.
Acha. Ki bollam? Affidavit of service. Where is your service?
Service, yes.
Service is on record. ठीक है. Paragraph. Learned advocate for the petitioner stresses on the
amendment to EMP
amendment notification.
Yes.
Being number 26 EMP
My lord.
dated 1st March 2016.
My lord.
Whereby the timeline for making applications, for making and considering the applications on application for appointment on compassionate ground has been extended. Stop. It has been submitted that the timeline has been extended for a period of 5 years from the date of death. Stop. Paragraph. I have heard the submission made on behalf of the petitioner and have perused the documents placed before the court. Stop. Admittedly, in the instant case, the father of the petitioner expired on 10th September 2008. Assuming that the application seeking compassionate appointment was made within the stipulated time period, even thereafter, it appears that the petitioner was not diligent enough to proceed with his claim for compassionate appointment. Stop. The appointment paragraph. Appointment on compassionate ground cannot be claimed as a matter of right, and the same is considered only for tiding over the immediate financial crisis faced by the family on the death of the bread earner. Stop paragraph. The amendment notification relied upon by the petitioner clearly specifies that in exceptional cases where where none of the family members is eligible for being appointed on compassionate ground, the department can consider the request for such appointment even where the death took place before 5 years. Stop. While considering 5 years. Stop. Paragraph. In the instant case, the petitioner was eligible for appointment on the day his father died in harness. Stop. It is for this reason that the application was made within the stipulated time period. Stop. The petitioner ought to have proceeded with the said application and approached the court at proper time. Stop. The petitioner has approached the court for the first time in the year 2026. Nearly 18 years after the death of his father. Stop. Had the petitioner been in such financial crisis that the family could not afford 2 square meals a day, the petitioner ought to have approached the court at an earlier point of time.
But my lord, the screening committee called me and examined my case. My lord, page, my lord, kindly sees for once, my lord, that screening committee. Screening at page 59. That decision was not even, my lord,
Stop.
in 2023, the screening committee called me.
Prayer of the petitioner for consideration of his case for grant of compassionate appointment in the year 2026. In view of the death of his father in harness in September 2008 cannot be allowed by the court. Stop. In view of the above, the prayer of the petitioner, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Next.
This is municipal service matter through the Municipal Service Commission.
Before I begin, I seek apology that state respondent has been served in full, but respondent number 6 and 7, that is Kolkata Municipal Corporation, has not been properly served. May I be permitted?
No, madam,
give the
Municipal
copy?
Service Commission also will not serve. Only with service has been made without annexation.
But may I then give a copy to both of you?
Give a copy, no issue, but the matter cannot be taken up by this bench. All right. The matter relates to municipal service. Let the same be released from the list of this bench and be bench for want of determination and be placed before the bench having determination.
It's my service and I have supplied.
Affidavit of service be taken on record.
Lord, I am not the petitioner, my lord. Lord, after filing this writ petition, my lord, subsequent events have been brought up. My lord, pursuant to my representation, they have served, my lord, copies of the merit list of the panel.
So your
My lord, I
grievance
want
is
to
redressed.
no, my lord, I have challenged the recruitment process.
Right.
Challenging the recruitment of a private respondent. My lord, I have served to the private respondents as well as the state.
You want to file supplementary?
Yes.
Achha.
My lord, only 2 days, my lord.
Yes.
Yes.
Learned advocate for the petitioner submits that after serving a copy of the writ petition upon the respondents, certain developments took place which are required to be brought on record. Stop. Leave has been sought for filing a supplementary affidavit. Stop. Paragraph. None appears on behalf of the respondents. Stop. Affidavit of service is on record. Stop. Leave sought for by the petitioner stands allowed. Stop. Let the supplementary affidavit be prepared and served upon the respondents. Released the matter on 8th June 2026.
My lord, before vacation, my lord, because I
Nobody is there for the state, sir. What can be done?
only, my lord, it may be, my lord, taken 22nd or 21st this month, my lord.
It cannot be
My
done.
lord,
Yes,
my application will be, my lord, in fracture because I have challenged the recruitment process as well as the private respondents recruitment.
Nothing will happen. The writ
My lord.
petition will remain pending.
My lord.
Next.
Yes. I am for the petitioner, Mr. Rajiv Rai is appearing there. He is appearing for the EPFO, Barakpur.
Are you there for the Employees Provident Fund Organization?
Yes, my lord. But
Are you aware of this matter?
no, my lord, I am not. I have not received notice.
Take
It's
instruction.
just, I'll take instruction if your lordship allow.
Instruction. Where from did you get him?
He usually appears, my lord. He sits
Please
here.
intimate your authority
Yes, my
that this matter is pending.
Yes, my lord.
Has notice been served?
Yes.
Where is the
I
notice?
can hand over a copy of the.
Certainly no.
I'll.
Serve the respondents. Service not complete. Let service be effected. Released 8th June.
Lordship. May I, my lord, take back the affidavit service?
Why?
I want to see whether service has been done.
Not take back. You can see certainly. Service has not been done. Please check up. Yes, next. Sure.
Lordship, I am appearing on behalf of NBSTC. Lordship, I get new appointment. Lordship, kindly.
On behalf of
NBSTC.
All right.
I get new appointment, Lordship. I kindly give some time so that I can take the specific instruction on all relevant documents in this matter.
Dispute regarding the calculation of the terminal dues of the employee on account of civil death.
Yes, Lordship.
Very well, please come. On the prayer of the learned advocate representing NBSTC to revert with written instruction released on 8th June.
But I am for the IRC. I am for the petitioner. Your lordship had on the last occasion
directed us to take a seek an instruction how to deal with the case of the petitioner.
Not instruction, to take a decision
On how to deal with the case of the petitioner who has been transferred from East Zone to South Zone in Bangalore. But his case is that his wife is serving a central agency in Calcutta. On that ground, he has filed an application in the writ petition. But I asked for information what happened because of the election. All our staffs here are doing the election duty. So we have on written instruction we have been requested to take 2 weeks time to take decision on this issue. And there is one point that is referred to in that instruction that I have handed over, is that there is a shortage of staff at the South Zone. This is thought to be they are trying to resolve this issue. If they can resolve that issue, then they can definitely that's the oral instruction. In writing they are saying they are asking for 2-3 weeks so that they can
2-3 weeks.
That's the I have
Weeks will take us beyond the summer vacation.
immediately before the vacation. I think by that time this election duty will be
over.
Most likely they will have to come
now
back with all
election
these
duty is over, my lord, before summer vacation, my lord, kindly fix.
Achha, learned advocate representing
and
the respondent seeks time to revert with instruction.
Yeah, just one.
So upon such prayer, release turn. See, today is Wednesday. I keep it Wednesday fortnight, that's 20th.
But I think
Right.
by that time there should be something in. And I have to
Who
find
is your client?
But
IRCTC?
yes.
Oh, how is IRCTC
these-
involved in election
all
duty?
the officers of these agencies have been deployed because of the election duty. Now that was also challenged. Lordship knows in a repetition.
20th.
And one more thing kindly my rejoinder to the exception taken by the petitioner to the original report filed in the court may be taken on record.
Again, rejoinder.
But
What are you saying in your rejoinder?
they will taken an exception to the report I filed.
I have
I'm
understood.
dealing with that. That's I dealt it long back, not now. But she could see that it is affirmed in November 2025. It was never.
Maybe long back, but then is it required?
But that's in the
Uh,
writ petition. That's
doesn't
not.
matter, since it is
This is not regarding the application. This
File
is
it.
regarding the writ petition.
the writ petition.
In the writ petition, I'm filing this, not the application.
All right.
In the application, we have not yet filed any.
All right. Writ petition it is all right.
November was served. It was never taken up there. Grateful.
All right.
My lord, may I indulgence? My lord, Lord, my junior mentioned one matter in the morning, my lord. Your lordship can take up that matter tomorrow. My lord.
I do not know which matter was mentioned. Tomorrow you have to see the list. Out of the blue, you say somebody
Item number,
mentioned. So many mentioning was mentioned.
That your lordship asked my junior that yes, immediately the matter to be taken up. He rushed to me and called me that the matter to be taken up, you please go.
Follow the list, it will be taken up. See, I am going quite fast. With your help, everybody's help.
Lord, item number
263. Let us see.
263 monthly list, my lord.
Let us see, not tomorrow. Follow the list, it will be taken up. Yes, what is this? Yes.
My lord, in item 14, Lord, I appear. In item 14, I appear for the petitioner. Lord, in terms of your lordship's order dated 8th April, Lord, the state was directed to file report. Lord, we
Your
have not
Lordship,
yet
I'm
received any
representing the
report.
Biodiversity Board. Your Lordship, kindly come at page number 58 and 62 once of the writ petition.
1 minute, let me hear what he has got to say and then I'll hear you. Yes, petitioner.
Now, Lord, the matter pertains to Lord area salary and Lord the interest. Lord, your Lordship, after hearing at the motion stage, directed the Lord respondents to file report. Lord, that was required to be served upon us. That has not been done as yet.
Respondents means the state?
Yes, Your Lordship.
No, it's the biodiversity
No, Your
board.
Lordship. Your Lordship, may I?
The board is here, just listen to what he has got to say.
Your Lordship, whatever the finance we received from the finance department, we have given the petitioner. You have kindly come at page 58 and 62. It is the finance department approval and order which have been passed without any giving retrospective effect. So finance department is the answering respondent and can explain that why they have passed this order. Lordship, it is there.
58 and 62.
Yes, Your Lordship. Kindly, and they have not challenged these two order, Your Lordship. Lordship, we have forwarded to the authorities. They have sanctioned the amount. We have disbursed them, and we have nothing to do with it.
No, possibly. If I can correctly remember, let me see whether I've recorded in it.
Yes.
He has been paid remuneration from 2018. His payment is due from 15 to 18. For the period 15 to 18,
Yes.
what is going to happen?
We have no information because we sent all his representation grievances to the finance department authority for the.
Sir, he was employed with you. And you say you do not know what salary he is going to get.
Your Lordship, until and unless finance department give us the
You
fund.
up with the finance department. Why will he go?
No. I am not asking him. Your Lordship, state finance department is the answering respondent. Let them come, Your Lordship.
Let them come. Did you ever contact with the finance department as to what will be the salary for a person who has worked there for 3 years?
Your Lordship, we have.
You expect a service for free?
No, Your Lordship.
Then?
We asked them and they pass this order and.
And you sit tight.
Lordship,
No clarification required as to how, why this salary for 3 years will not be paid. Is it the case?
We have handed over to the finance department and finance department approved it, Your Lordship.
You cannot expect somebody to work for you without paying anything, isn't it?
I understand completely, Your Lordship, but until
Then please take it up with the finance department. It is your responsibility because he was serving your department. The learned advocate representing West Bengal Biodiversity Board submits that the payment has been made to the petitioner in terms of the direction of the finance department. Stop. The paragraph fact remains that the petitioner was appointed as the chairman of the board and he has not been paid any remuneration / salary for the period 28th March 2015 to 27th August 2018. Stop. The 27 August 18 the employer would be bound to pay for the services rendered by the petitioner for the aforesaid time period. Stop. There is nothing on record to suggest that the petitioner did not serve the board for the time period mentioned herein above. Stop paragraph. Hearing of the writ petition stands adjourned till 8th June 2026. Stop. Positive written instruction from the board regarding taking up the issue with the finance department shall be placed before this court on the adjourned date.
We will forward this order with the authority and we will come.
With my senior's permission, only one thing. Page
I'm
61.
extremely grateful tomorrow.
Page 61. would
Extremely grateful.
What they are passing it upon the finance is not correct because
All right, next
they
day.
had fixed it.
Next day I'll see.
Fine. Grateful, my lord.
And for the petitioner, this is affidavit exception to the report.
Report has already submitted, my lord. The exception is.
What is the issue? Where is the DME?
Sorry.
Where is the DME? Unfit?
Yes, unfit, my lord.
On the ground.
My lord, can you kindly come to page number 26 of writ petition?
26, yes.
26 and 27.
26 and?
27.
Yes.
My lord, my client has been operated in Narobi hospital where he got his right ear operation and Thereafter, in page number 33, after the operation, he appeared before the review medical examination and he has been declared as fit. Then
Unfit. He was declared unfit on the ground of, my lord.
Post tympanoplastic graft
Post-tympanoplastic-
and mild discharge.
Yes, lordship.
My lord, after the operation, he has been declared as fit. But
Page 25, it is dated 20.
again, he has been appeared after the operation. He has been declared as fit.
By whom?
My lord, kindly come to page number 33 by review medical examination. 23rd October 2024. He has been declared as fit. And then again the operation, again he had appeared before the review medical examination on 21st November 2025 and then he was declared as unfit.
Yes.
After lapse of around 1 year.
Yes.
After the operation he has appeared and he has been declared as fit. And then again after when he appeared after 1 year he has been declared as unfit.
Yes. Where is the problem? He cannot be unfit after 1 year.
No, my lord, I'm not saying that.
A person who is fit on a particular day will remain fit for eternity.
No.
Then?
Therefore, here in the exception to the report, in page number 5, I've attached a Christian Medical College report of Vellore, where in the diagnosis it's written right chronic otis media post right tympanoplasty status with intact tympanic membrane. So, according to Uniform Medical Guideline, which is in page number 22, in minor acceptable defects column, point number 7G. Over here, it's written heel tympanic membrane perforation means. According to this, he should be the minor acceptable defects can be considered. So, according to CMC Vellore report, it means that he has healed the tympanic membrane.
25 is the review medical board report. Stuff. Reliance has been placed on the report of the Christian Medical College Vellore. Exception by the petitioner to the report of the Union of India retained with the records. Next.
My lord, I'm paying for short time to file the extension of filing the exception because my lord, due to election, he has
All right.
left
On the
the
prayer of the learned
house.
advocate
My lord, 2
presenting the
days, my lord,
petitioner,
can be accommodated.
time to file the exception to the report
Next week, can it be?
stands extended further. No, extended 1 second. Till, no, next month.
No, my lord, kindly takes up this vacation. But otherwise, they will again.
Examination of 25.
Yes, examination. Well, I have prepared, but I make a telephonic con. I am left of my house due to this situation.
Extended till next Wednesday.
Next Wednesday.
Today is Wednesday.
Yes. Next Wednesday, then your lordships can fix the matter any day.
13th. 13th.
13th, my lord, 14th.
At the 15th. Released on 19th.
Friday, my lord.
Friday, he'll prepare the exception and serve it upon you, and the matter will be taken up on 19th.
Much obliged. Yes. 17, my lord, I am for the petitioner. I have built with this is the exception.
He has filed this
Exception I have served to my learned friends. My lord, this is the case where kindly come to page, my lord, 25 of my REIT application.
25 of your?
REIT application.
Yes.
My lord, here 3 grounds has been assigned by the detailed medical examination board. My lord, where high BP indicated high BP, accessory nipples, that should not be a ground for rejection.
All right, review medical board.
And underweight by something.
Review medical board.
Review medical board, my lord, kindly come to page
26.
Hmm.
This is the review medical guide board decisions.
Hmm.
Here, my lord, both the ground, that is the high blood pressure and underweight, I have passed.
Hmm.
New ground come.
Inferior ischemic
Ischemic change in echo. That is with related to the hypertension.
Achha.
Without admitting my hospital, they have decided this. And another thing, accessory nipples. Accessory nipples, there is nothing with the interference with the duty.
What is the
Yes, my lord, that is the exception they have taken. Interestingly, they have taken this point, my lord, that this ECG has been done. ECG, echocardiogram, my lord, had been done for the purpose of the accessory nipples. That is not done. That is for the purpose of hypertension, high BP. And my lord, kindly have a look on the
inferior ischemic
exception filed by the respondent authorities. My lord,
the report contains the ECG report.
Yes, ECG reports.
And
Interestingly,
it is mentioned inferior ischemia suspected.
yes, that is for the hypertension. I have passed that ground. They have declared fit in the hypertension. No. Yes, my lord. They have declared me without, my lord, kindly come to, my lord, take my exception to the report.
No, you come to the review medical report.
Yes, review medical report, page 26, my lord. Page 26 of my, my lord.
Inferior
Here also there are
charges. They are
yes,
mentioned
very much
inferior
yes.
charges.
Yes, but kindly have a look the contention made in the paragraph 3 of the my lord, report.
Oh, for
Kindly have a look on the paragraph 3. What they have been mentioned?
Maybe see page 26. I can see there is an ischemic change mentioned.
Yes.
And this ischemic change, they have relied upon the ECG report.
Next line, kindly have a look on the next line of the ECG report. Please correctly correlate clinically. It is not correlate with the clinically because the doctor in cardiologist, wherefrom they have taken opinion, he said that the patient is very fine, no cardiological dispute is there. Admitted in the report. Kindly have a look on the paragraph 3.
Yes.
Therefore, my lord, this paragraph starts, therefore,
thereafter,
a review medical examination of the petitioner was conducted by the BSF Nodia Center on 1st December 2025 by the separate review medical examination RME board comprising 3 medical officers. The board examined the candidate and rule out underweight by taking BMI such and such accepted per policy. The board also ruled out hypertension. The ECG has been done for the purpose of hypertension. They have ruled out. After measuring blood pressure as per policy or obtaining a specialist opinion, they have admitted it. However, the board also mentioned the candidate having an accessory nipple and sent to the candidate to the specialist opinion and investigation to the JNM hospital. It is not to the THISM, a private for ECG hospital. Their diagnosis report with doing the investigation report, paragraph 4. The board was also found out the candidate ECG report shows interfere ischemia changes which are ground for rejection. They cannot show anything regarding this point that this is a ground for rejection. It is related with the cardiology, and the cardiologist specifically mentioned that I have no cardiological problem. Kindly visualize the situation of an unemployed youth.
1 minute. Try to understand this also. Paragraph 3, they say underweight was ruled out.
Ruled out.
And hypertension ruled out. Was board ruled out hypertension?
Ruled out. Yes.
Thereafter, it was again investigated and the
for
investigation...
the accessory nipples. For the accessory, they have admitted. Kindly have a look first line of the second page of the report.
ECG report does not have any relationship with the accessory nipple.
Yes, I am on the point. What is fallen from your lordship's mind?
So
I am on the point.
ECG is only
for
to a certain
cardiological problem, cardiological issues.
Heart, ischemic heart also.
No, It is related with my heart.
Ischemic heart, it is the ECG which will find out.
That ground has not been assigned in the DME.
No, it is
They
there.
cannot go beyond their jurisdiction. Kindly have a look on the page, my lord. In my exception, I have taken this specifically, taken this point. Kindly have a look. My lord, kindly have a look, page, my lord, 6. First, kindly take page, my lord, 8 of my report, exception to the report. Page 8. My lord, kindly have a look. How they have done.
Understand one thing, I can very well feel that an unemployed youth is trying his best to get a job over here.
Yes, and with this silly and with there is no problem with my cardiology in cardiac.
It is you who say, I am
I'm putting this
absolutely
question.
fit.
Yes, I am.
You never know. In the CRPF, BSF, the conditions in which they are required to serve.
Yes,
In
I
the
know, my lord. That's why 5-kilometer runs is there in initial stage.
5 kilometer
I have
run is
completed
not
5-kilometer runs within 24 minutes. My lord, if I have suffering any cardiological problem, I am putting this question to myself: can it be possible for a person who has the cardiological problem to complete the run 5-kilometer runs within 24 minutes?
I do not know. The doctors, experts are there. they
Yes,
will
I am
say.
saying that. I am also saying that, my lord. Kindly have a look on page 8 of my exception to the report.
Yes.
Paragraph 12.6.2.
Hmm.
This is very relevant.
Hmm.
My lord, the employment notification. It is a part of the employment notification. They have ascertained that this medical examination will be done as per the guideline given in their notification such and such. I am, my lord, annex that notification. Kindly come to page 10 of my exception. Page 10. That is the notification.
Yes. Yes.
Page 10.
Change is
And
11.
my lord, page 12. Kindly come to relevant. Annexure A is the relevant. In the page 10, it has been mentioned that this should be followed.
Yes.
My lord. Guideline for review medical board. First, 6, clause 6A. The review medical board shall examine the candidate specifically for the deficiency for which the candidate has been declared unfit. Also, the medical term used in the cause of unfitness during the initial medical examination may be different from the arrived at by the review medical board. Then kindly come to next page, page 13, clause D. Clause D. The review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. Malat, the ECG report, the second line is specific. Please correlated with the clinically. It is not clinically correlated with the report. Malat, I am coming to that. Therefore, in case of rejection, kindly have a look on the sentence. In case of rejection, in review medical examination, clinical findings should be corroborated with conformity test. Here, in this case, the clinical finding is not corroborating the investigation ECG report. That is my specific case. Investigation opinion of the specialist, super specialist, government hospital. Here, the specialist opinion also not corroborated with the rejection order. And moreover, clause 8, page, my lord, 14. It is also very much relevant. There are few examples. There are some examples. Oh, my lord, I have skipped one point, my lord. 7E. Kindly have a look, page 13. 7E. The candidate who have been rejected on the ground of hypertension, tachycardia should be admitted, hospitalized by the board. In this case, no hospitalization, no admission on the hospital. Before giving their final opinion regarding candidate's fitness or otherwise, they are suspecting I am suffering for cardiac problem without following their own guideline, grossly violated their own guideline as per the employment notification. I am not seeking that this is the subsequent event. In the employment notification, as they have mentioned, they should follow this guideline. Once an unemployed youth for seeking for an appointment, only for this reason cannot be rejected. This guideline should be followed. In this present case, they have not been followed the guideline. They have took the ECG for my cardiac problem, taken the specialist opinion. The specialist also opined in favor of me that I have not suffering any cardiac problem, and they have rejected on that point. And next point is accessory nipples. In the medical guideline, revised medical guideline 2015, there is no whispering about the accessory nipples. It is my birth, from my birth, and from my the thing is from my birth cannot be rejected by this way. If it is an extra the extra finger or anything like that, it is a deformity or disease, they may reject on the ground my candidature. This is my another point. Paragraph 8 also says that same thing. The candidates are concerned investigation whether and whenever applicable. Rejection merely on the clinical findings is to be avoided. They cannot only clinically find, based on the clinically finding, cannot reject. Without obtaining any specialist opinion and clinical findings, they cannot reject my candidature on the base of the investigation report. This is the procedure specifically mentioned in their own guideline. Without following that, they have rejected on the ground which is not applicable. One ground is not applicable for me, and another is not a ground for rejection as per their guideline. That is my submission, your lordship. And another thing is the Dibbangshu, the Honorable Supreme Court specifically mentioned in this case, your lordships although know this matter, the Honorable Supreme Court was pleased to appoint the AIMS School, Delhi, a doctor and board of doctors to examine the retina problem and eye dispute. There also the Honorable Supreme Court was pleased to direct the AIMS Delhi to constitute a board and examine. In this specific case, there is various diversion of opinions of the recruiting board, as well as the no corroboration with the specialist opinion, diagnosis report, and the clinical findings and the rejection order. As per this judgment I am paying before your lordships, kindly send this matter to any other independent authority for examination, further examination, and keep the matter pending. If your lordships found that this is not the fit case, they have declared me that unfit. I am suffering that as per the ECG report, I am suffering that problem. I have no case. I will be out of court. That is my submission.
Milord, first thing is, Milord, the paragraph 8 of the report. Paragraph 8, which my learned friend has referred to, I am referring to that paragraph itself. The paragraph 8 speaks of, Milord, that exceptions to the report. That in the case, Milord, a paragraph 7E, exception.
Page 14 of my exception.
Page 13.
13, yes.
Yes, Milord. 7E. For candidates who have been rejected on the ground of hypertensions, which is not a ground here, Milord, tachycardia should be admitted. So it is not a ground, it is neither hypertension nor tachycardia. Secondly, Milord, what has been stated to have been done in all such cases, X-ray and electrocardiogram examination of the heart should be done, which we have done. And what is the report of the electrocardiogram report? Milord, it speaks of at the bottom inferior ischemia suspected.
Suspected.
So yes, doing a duty in an armed force where he had to run to the desert or to the frozen tablets or a plain land or a jungle is a minor defect, not be a very crucial. He is not doing a clerical job in a city environment. He'll be doing a job in some of the toughest environment, have to be physically fit more than anybody. It cannot be compared with a common person. And Milord, I have got the judgment. Milord has also refer the judgment in Sohail Rana in one of my case. Milord, this is Rana. ওই যেটা সোহেল রানা মন্ডল যে জাজমেন্টটা পাস করেছেন আগের যেটা ডিসমিস এই হলো ডিসপোজাল হলো মিলর্ড হ্যাজ পাসড ইট এন্ড মিলর্ড আই হ্যাভ গট এ জাজমেন্ট ওই এটা দাও জাজমেন্টের কপি তলায় আছে দাও দিস আই এম রেফারিং টু ইটস অলসো ফলো দি সেম লাইন a single big judge which has spoken of that no, this also speaks of Milords. We have annexed it with our report, Milord, that in a case, Milord, where it consider for the armed forces where the toughest job are being done, Milord, it cannot be like that. And a report from outside will also not be considered because the doctors who are examining
Which paragraph?
Milord, paragraph. Milord, the paragraph is, Milord, Milord, paragraph 9, page 4, paragraph 9. Paragraph 9, then Milord 8, last paragraph. The principles that apply in the case of recruitment to the disciplined force involved with safety and security, internal, external, such as armed force and paramilitary force or police, are distinct and different from those which apply to the normal civilian recruitments. Milord,
This is in reference to another matter. All right.
and Milord has passed. Milord has passed it. I can give the reference in one of that. It's exactly following the same. And secondly, Milord, outside medical examination, it cannot be placed over the report of the internal mental examination because in these cases, they are more fit than this. That has been also been held, Milord, in page 7, para Milord 5, sub-para 5, opinion of the private. So, Milord, it will prevail. Our report will prevail over the opinion of the private. So, in the case, somebody who is doing in the armed forces, who has to deal with one of the toughest terrain, cannot and should not be compared with the persons who are doing ordinary duties.
Very well.
My lord, may I give my reply?
Okay.
My lord, my learned friend took the point that the toughest and my lord, different and distinct nature of the duty. My lord, this is the recruitment process. My lord, here we have floated the guideline for identifying any deformity and disease. May I put this question to myself that having a MBBS degree of civilian doctor and the paramilitary doctors are different? I think no. Well, detection of deformity and disease, it can be done by any specialist doctor, whoever may be in the armed force doctor or in the civilian doctor. The deformity and disease can identify or indicate any of the doctors. If I am suffering that deformity or disease, then I have no right to go in the job. If that has not related with my any deformity or disease, this is the medical guideline, why this medical guideline and medical examination is required for this job. For identify any the candidate has suffering for any disease or having any deformities or not. Well, if a doctor can identify or indicate that this person has no such deformity, then it can be said that the doctor who is in armed force, he can identify that thing. If this diversion is there, two different opinions are there, then I should pray before your lordships, these things should be done by any other independent doctor. If there is any deformity or disease, then I have no chance, or otherwise, your lordships, if that has not been done, your lordships will prejudice unemployed youth. Because if I have no disease or deformities like that, as the rejection order says, then I should be deprived for getting a job in this situation. That is all of my suggestion. And it is a Allahabad Court judgment, my lord. Honorable Allahabad Court passed this judgment, and I have submitted the Honorable Supreme Court judgment.
The petitioner
Kindly consider.
participated in the recruitment process of CAPF. Hyphen 2025. Stop. He was declared medically unfit by the detailed medical examination board on the ground of high blood pressure, comma, accessory nipple and underweight. Stop. The petitioner was checked up by the, not checked up, physically examined by the Review Medical Examination Board, and he was declared unfit on account of inferior ischemic changes and accessory nipple. Stop. Paragraph. The petitioner got himself checked up by the state government hospital where he was declared medically fit. Stop. It has been submitted that কাটুন লিখুন যে challenging the manner in which the medical examination of the petitioner was conducted, comma, the instant writ petition has been filed. Stop. A report was called for from the respondent authorities, which has been filed, and an exception thereto has also been filed by the petitioner. Paragraph. Specific contention of the petitioner is that the respondent authority did not abide by the medical guidelines pursuant to which the medical examination ought to have been conducted. Stop. Accessory nipple is present in his body since his birth. Stop. The same is not a deformity. Stop. The same does not interfere with his regular work. Stop. Paragraph. It has been submitted that the authority did not obtain specialist opinion after ECG of the petitioner was conducted. Stop. The ECG report.
That is not my case. ECG after ECG they have obtained a specialist opinion.
They have.
Yes, they have. They have annexed the document. I have annexed the document also. And cardiologist, from the cardiologist.
It has been submitted that the ECG report ought to have been correlated clinically, which has not been done. It has been submitted that, paragraph there, the report of the state government hospital ought to be taken up for consideration as the doctors of the state government hospital have the same educational degree and the knowledge of medicine similar to that of the doctors, physically examining the petitioner by the recruiting authority. Stop. Reliance has been placed on the order passed by the Honorable Supreme Court on 29th May 2025 in civil appeal number such and such in Divyanshu Singh versus Union of India and others, wherein the court directed the candidate to be medically examined by the Medical Board of AIMS, New Delhi. Stop. It has been submitted that the case of an unemployed youth ought not to be, unemployed youth seeking appointment ought not to be brushed aside slightly. In such a light manner. Stop. The authority is interfering with the right of the petitioner to be considered for appointment. Stop. Prayer has been made to either re-examine the petitioner medically by an independent authority or to accept the medical report given by the doctor of the state government hospital upon setting aside the medical report of the Review Medical Examination Board of the recruiting authority.
My twofold prayer. That is one, and second one is the first one is the reference to any other independent authority to examine, and second one
is this.
Yes, that is first.
Either one.
Yeah.
First, second. Next. The submission of the petitioner, submission and prayer of the petitioner is opposed by the learned advocate representing the respondents. Stop. It has been submitted that the that a person appointed in CAPF will be required to perform duty under extreme pressure and weather condition. Stop. The physical fitness of the candidate employed in the armed forces has to be checked up in a very strict manner so that the health of the employee does not interfere with the duty assigned to him. Stop. Paragraph. It has been contended that the petitioner was examined medically first by the Detailed Medical Examination Board and thereafter by the Review Medical Examination Board. And on both occasions, he have been declared unfit by the expert doctors. Stop. Report by any other doctor cannot be accepted, and the report of the experts of the recruiting authority ought to prevail over the report of an outside outsider medical examiner. Stop. It has been contended that the medical guidelines for recruitment has been scrupulously followed by the authority. Stop. Prayer has been made not to interfere with the report of the medical experts of the recruiting authority. Stop paragraph. I have heard and considered the rival submissions made on behalf of both the parties and have perused the materials placed before the court. Stop. In the instant case, the petitioner is contesting for being appointed, contesting for appointment in CAPF, comma, a disciplined body. Stop. The recruiting authority has its own specified, comma, codified medical guidelines which are required to be followed for the purpose of conducting medical examination of a candidate intending to be recruited in the disciplined forces. Stop. The subparagraph, the submission made by the learned advocate for the petitioner that the report of an outside medical practitioner may be considered for adjudicating the physical health of a job aspirant in CAPF by disregarding the report of the experts of the recruiting authority cannot be accepted by the court. Stop.
My lord, may I?
Yes.
My lord, Annexure 3 of their report says they have opted. My lord, it is not outside my report.
You have relied upon the state government hospital's report.
That is in support of my case, but they have also.
Yes. Very well.
They have also.
Very well.
Annexure 3 of their
Very well.
report filed by them. They have also relied this.
আচ্ছা এরপর লিখুন যে
JNM Hospital's report, cardiologist.
The a candidate participating in a recruitment process of the disciplined forces would be bound by the recruitment rules of the said forces and the medical guidelines relating to the said forces. Stop. The authority, the authority took the opinion of the medical experts twice, semicolon, first before the detailed medical examination board, where the petitioner was declared medically unfit on 3 grounds. Stop. Thereafter, the medical condition of the petitioner was reviewed by the Review Medical Examination Board and he was found unfit on 2 conditions. First, inferior ischemic changes, and second, accessory nipple.
And first ground that was not taken in the detailed medical examination.
Stuff. The ground of high blood pressure was not accepted by the Review Medical Examination Board. Stop. Next, the authority conducted ECG of the petitioner and the ECG graph has been annexed to the report. Stop. The observation mentioned in the said graph, signed by a consultant cardiologist of a diagnostic center, specifically mentions of inferior ischemia. Stop. The said abnormality was to be correlated clinically. Stop. Paragraph. Learned advocate for the petitioner contends that the clinical correlation of the ECG graph was not conducted.
Yes, conducted. Well, prior to that page. Yes, last line. Cardiologist. Here, clinical, the references in the endocardiology referred the doctor to endocardiologist. The cardiologist
Which
said
page? Which page?
Page annex 3, that index page, that ECG report prior to that page, previous page.
This one?
Yes.
Report or their report?
Their report. In their report. Last line. Referred to the MOPD for endocardiologist. This doctor referred. And the endocardiologist, second page, second line. Patient medically fit after going through that ECG. After going through that ECG.
This page are you referring to?
Yes, I am referring that.
Yes, referred to MOPD.
Yes.
Thereafter?
Thereafter, the last line. Patient medically fit. Patient medically fit. This is the cardiologist. This is the after getting that PHYSIMS report. They send me to the JNM hospital for a specialist opinion. My lord, the specialist doctor for first, the doctor is surgical doctor for accessory nipples. He found that accessory nipple is not the, after various tests, going through that various tests, that it is not contingent in nature. It is normal and it is the since my birth, and thereafter referred.
But this reference is only for the accessory nipple.
No, my lord, last line, the accessory doctors, when they have produced the ECG report, then he refers me to endocardiologist.
No, sir, this page that you are referring to, the department is surgical male, and the advice was sought for only the accessory nipple, and he has been found to be medically fit.
Yes, but
this is not regarding the ECG.
My lord, the referred to the MOPD for endocardiologist.
That is different. That is different. That is not the ECG.
My lord, that is, they have obtained that report.
How can, listen, try to understand, how can the surgical department comment upon the ECG? It can never.
Not surgical department. This is the endocardiologist. My lord, the referred to the MOPD for endocardiologist report opinion.
Where is that opinion?
The next Dr. Sunit Chatterjee, that is a different doctor.
That is a different doctor only for the accessory nipple.
They have obtained. It is not my document. They can clarify whether they have obtained or not.
This
is
clinical
my client instructed me that they have produced all those documents to the surgical doctor. He has referred this endocardiologist. That this is not my business. They go for the cardiological department.
Was not conducted, and the petitioner has been found to be fit. ওটা কি বললাম তার আগে fit by the doctors of JNM hospital. On a perusal of the report, perusal of the
these document, may I one second,
patient card.
May interference, otherwise I shall not. Paragraph 3 of the report are contradictory. But paragraph 3, they have ruled out the hypertension without consulting the cardiologist, without going through the ECC report. They can.
আচ্ছা লিখুন তো ওই
That
যেটা
is
বললাম
their
না
document. They can.
কি বললাম
They have done. It is my specific instruction, madam.
হুম,
That's why.
হুম। Dated 1st December 2025, issued by the Surgical Male Department of the College of Medicine and JNM Hospital, comma, WBUHS, comma, Kollani Nodia. It appears that the patient was checked up for obtaining medical fitness for accessory nipple. Stop. The doctors opined
মোহাম্মদ আলী এরপরে যেটা মোহাম্মদ আলী এই জন্য
this page, how are you reading this word? Referred to?
That is, I have mentioned in the exception. I have mentioned it properly.
Yes, what is it? Referred to?
Endocrinologist.
What is the work of an endocrinologist?
That is related to the accessory. Your lordship is correct. I have checked.
Endocrinologist looks about the blood sugar and the endocrinology, the endocrine.
Hormonal disorders.
This
That
has
is
got
why-
nothing to do with the heart.
But they have done it as per their statement in paragraph 3, and as per the instruction of my client, they have checked it by the cardiologist from the JNM, but they have intentionally did not annex that document.
The doctor opined that the petitioner was medically fit on the ground of the not the ground as regards the accessory nipple. Stop. ঠিক আছে? The it appears that the ECG chart, ECG graph of the petitioner was checked up by the medical experts of the recruiting authority, and the petitioner were and inferior ischemic changes were detected. Stop. The medical guidelines
minor acceptable defect, inferior
mentioning the grounds for rejection clearly mentions that indication of valvular or other disease of heart and any congenital abnormality so as to impede efficient discharge of training/duties are the grounds for rejection. Stop. Paragraph. According to the authority, comma, accessory nipple is a congenital abnormality and the same may cause constant friction in an abnormal area of the body while wearing combat gear during training and hard duties. Stop. There is an established positive association between an accessory nipple and coronary heart disease. Stop paragraph. Submission of the petitioner that he could complete the run within the prescribed time period is an indication that he is absolutely fit, cannot be accepted by the court. Stop paragraph. At the time of conducting the run, the petitioner was certainly not wearing any combat gear. Stop. He must be wearing his regular dress. Stop. The authority has opined that with the combat gear, there may be a chance of constant friction if there is an abnormal area in the body. Stop. Such opinion of the expert authority cannot be brushed aside lightly. Stop paragraph. As regards the inferior ischemic changes, the petitioner may not face any problem at present, but it cannot be ruled out that the same ground, which is a ground for rejection, will not cause any impediment while the petitioner is on duty. Stop paragraph. The paragraph 7 টাকা কপি করবেন তো এইখান থেকে। The submission of the learned advocate for the petitioner that the authority ought to have taken further specialist opinion if there is any doubt. Stop. It does not appear that there was any doubt in the mind of either the detailed medical examination board or the review medical examination board as regard the inferior ischemic changes and the accessory nipple of the petitioner. Accordingly, there is no question of obtaining further opinion from the specialist or super specialists of the government medical college or hospital. Stop paragraph. The submission of the petitioner that that he ought to have been admitted / hospitalized by the board before his rejection on the ground of hypertension also cannot be accepted in view of the reason that hypertension was never the ground for rejection of the petitioner's candidature. Any other point?
High BP and hypertension same.
Any other point? Your point which I have not dealt with, so that you can take that in the appeal court. No, you please say so that I will deal it here only. Yes, respondent, any of your point which has not gone down?
They are coming from.
Lord has taken up all the points referred to the guideline. I have nothing.
Only one point.
Yes. What other point?
Their report, paragraph 3.
Paragraph
Hypertension
আচ্ছা,
and
ঠিক আছে,
high
paragraph-
BP is the same.
ঠিক আছে, ঠিক আছে,
They
paragraph-
have admitted it.
ঠিক আছে, paragraph 3.
No.
Learned advocate for the petitioner also submits that the submission made in paragraph 3 and 4 of the report are contradictory to each other.
Yes.
Right? It said submission also cannot be accepted by the court in view of the fact that hypertension was not the final ground for rejection of his candidature. The candidature of the petitioner stood rejected, relying upon the ECG report, which showed inferior ischemic changes and accessory nipple. In view of the above, no relief can be granted to the petitioner in the instant writ petition. The writ petition fails and is hereby dismissed.
Well, item number 21, I have an instruction to withdraw this matter. 21
Yes.
Withdraw.
সাড়ে তিনটে বাজে।
Item 21.
21, my client has instructed me to withdraw because he could
He's
not,
got job.
No, my lord, he could not qualify the cutoff marks. 4
Okay,
marks
yes.
behind this. The last
21.
We thought it only will be taking up now it is 21, no further. Because the
Next one is
20 is mine.
It's আজকে
What
সাড়ে
is the
তিনটে।
time?
আজকে সাড়ে তিনটে।
It's long over.
Lord,
এটা
that is
উল্টে-
why I am asking.
No, since he mentioned he will not press, that is the reason. Wait, item 21 to record going to learned advocate for the petitioner submits that his client is not willing to proceed with the instant writ petition not pressed.
My lord, the
Communication
instruction
from the client be written with the records.
deeply obliged, boss. Much obliged. Let me-
দেখে নেবেন আমার
No,
কোনো
no.
order আছে।
My lord, I'm thankful to your lordship. Your lordship is allowed to so much time. Deeply obliged, your lordship.
Better to do it in front of you so that if there is anything left out, it can be checked. Otherwise, once I go to my chambers, I miss certain things. There are chances that you may miss and you
These
take
are
that
such
in appeal that the court has
factual
not
details.
considered. Factually, the court has not considered. So, all points considered, dealt with. Now let the client go in appeal whatever he feels like doing.
Obliged, your lordship. Grateful to lordship.